from the list below, it's a eviction related matter. From the list below, if I may mention below, it's eviction related matter under order 4111. Similar matter has already been admitted by your revision.
Which one?
It is at serial number 47.
Similar matter means how two cases are similar to each
So
other?
the question of law which has been framed by your revision, whether once terminated, can the tenant and landlord relationship be revived automatically? It is on that issue.
Get that order? Come in the second. Now, we'll file it out.
From date this orders item 1, second appeal 57 on 1987.
Yes, sir.
Yes, sir. So I may ask to be appeared on behalf of giving Okal as per the previous order.
5A.
5A.
Yes. Address not found.
See, he has, somebody has appeared below.
Who has appeared?
The earlier advocate. 5A is appeared.
No, so in this case, I have got the information.
5B to 5D has appeared. ऑफिस नोट नहीं देखते
देखें
हैं
उधर है उसमें कि 5A की तरफ से वकालतनामा फाइल किया गया
5A की तरफ से
यद्यपि सर्विस नहीं हुआ था लेकिन 5A की तरफ से
दिखाई सर बताइए कौन सा ऑफिस शो पेंसिल दीजिए और ब्लॉक करके बताइए गिव मी माय पेंसिल
5 एक्सपायर कर गया
I just so I am just absolutely clueless कि हम आपका क्या करें pencil give me my pencil like get a mark it like 5A has appeared by 5A वकालत okay counsel for the parties are present you are appearing for 5B to 5D
Yes, ma'am.
the learned counsel for the learned counsel appearing on behalf of respondent number 5B to 5D has submitted that 5A has expired.
Yes,
Okay, legal years?
Lord's legal as I am not having the information, but I will give
When
it to
did
you.
it end?
Lord's just this seal.
sorry madam has not been filed.
Please don't say sorry to me. You know, I'm absolutely fed up with this.
If 5A has not been filed here,
23/18
Sorry,
23/1/2018
has filed on 23/1/2018.
died
Has died on
23/1/2018
2018. 5A has died.
Five.
Right.
Subhash Chandra Bose.
Subhash Chandra Bose. इनका legal years का provide करते हैं
जी
The learned counsel for the respondent submits that he shall provide the details of the legal years and successors of respondent number 5A to the counsel for the appellant within a period of 1 week. Post after 10 days. 10 days के बाद कोई डेट नहीं आपको भी तो स्टेप लेना होगा
जी वो
आईडी कॉन्टैक्ट विद योर क्लाइंट और नॉट
कॉन्ट्रैक्ट किए थे लेकिन इसके बारे में मालूम नहीं
पोस्ट ऑन 8th of October
ये भी अपने साइड से एक बार देख लेंगे इंफॉर्मेशन तो आया है
आपके
सारा
पास डेथ सर्टिफिकेट आ गया है और कौन सा इंफॉर्मेशन चाहिए
तो भाई भतीजा थे वो लाके दे दिए हैं आई विल आल्सो इन्फॉर्म हम ये नहीं बोले यार गिवन द अंडरटेकिंग माय लॉर्ड बट वो भी देख लेंगे अपने साइड से
अपना जो भी आपके पास कॉपी है ना
उसी का
उनको प्रोवाइड कर दीजिए ही विल पुट इट ऑन द एफिडेविट अगर आपको कोई ऑब्जेक्शन होगा एनी ऑफ द रेस्पोंडेंट देन दैट कैन ऑलवेज बी टेकन ओके बिकॉज़ डेथ सर्टिफिकेट शुड बी ऑन record.
यस दैट इज
Item 2, second appeal 69 of 1997.
This case, Lordship, has been admitted by this honorable court. My Lord, in this case,
Yes.
I filed my appearance on behalf of 2, 3, and 4. Respondent number 2, 3, and 4. However, respondent number 1 is no more. My Lord, he died in the month of January 2004 itself. And
January 2004
my Lord,
respondent number 1
my Lord, Fagua Matra. And I have given the information with regard
He
to
just handed over the
names of legal years of the respondent.
Essay number 69 of 1997 with the bracket R. The respondent number 1 has expired in the month of January
2004.
You have got a death certificate?
No, my lord, because he died in the village, no certificate has been.
Okay. In the month of January 2004, the learned counsel for the respondent has submitted that he has recently received this information, and the names of legal heirs and successors of respondent number 1 has already been handed over, has already been intimated to the learned counsel for the appellant. Learned counsel for the appellant seeks adjournment. Kab चाहिए?
2 weeks to our lord.
Post on 25th.
Item 3, second appeal 73 of 2001 along with item 4 and 5.
Your ladyship, IA has been filed to replace the sole appellant. He died on 15/6/2025. And para 5 contains list of legal heirs.
Who is for the respondent? Any other person yet to appear? The respondents are appeared. There is one more for formulating further substantiation of this. That also you have filed. Essay number 73 of 2001. Counsel for the appellant is present. Nobody appears on behalf of the respondents as per the office note. Service upon the respondents is complete. The learned counsel for the appellant, your name please?
Jeet.
G. Mr. G has submitted that IE number 11422 of 2025 has been filed for deletion of the name of the sole appellant and for substitution. They are already on record, no?
No.
The learned counsel submits that the appellant has expired on 15/6/2025 and petition seeking substitution has been filed. The names of legal heirs and successors has been mentioned in paragraph 5 of the interlocutory application, and their wakalatnama has also been placed on record. Considering the interlocutory application, considering the submissions, IA number, the apostate IA is hereby allowed. The learned counsel for the appellant is directed to delete the name of the sole appellant and insert the name of the legal heirs and successors in red ink during the course of the day.
Your ladyship, 3, 4, 5.
Just a moment. Sorry,
3, 4 and 5 are connected.
3, 4 and 5 are
There
connected.
are 2 cases.
So
They are also
appellant
have-
is same. Appellant is
Same
same.
order,
Yes.
IA number बताइए.
IA number 3622.
उसमें भी सब लोग appear कर चुके हैं. Is there anybody yet to appear? Those matters have yet not been admitted.
No.
Substantial question of time to bring, not bring.
I've,
आप तो नए लगते हैं, आपको कभी देखे नहीं.
first time.
First time. That's it. Which college have you passed out?
UPS Dehradun.
What is the IA number 5 here?
IA number 3622 and 3624 in fifth.
इसमें IA नंबर है
particular 11423.
इसमें 11423 of 2025 ठीक है इसमें भी सर्विसेज कंप्लीट इसका दिस इज फॉर एसे नंबर 74 of 2001 105
1141.
This is IA number 11417 of 2025 in SA number 75 of 2001. $75 million you have to take care of it. As per office note, respondent number 1 and 1C has expired and their legal years have been substituted by the order dated 11/8/2008. But notice has not been served. Notice has not been served. How many legal years were of respondent number 1C? Two. The mismatch here. ऐसे लिखो as per order dated 11/8/2008. The substitution with respect to respondent number 1 was allowed while IA number 1691 of 2007. But the office has pointed out that notice has not been served. It further appears that by the same order, IA number 966 of 2008 was allowed, deleting the name of respondent number 1 within bracket 6, 1 within bracket C. The office note reveals that the legal years of respondent number 1 within bracket C has been served through process server. In view of the aforesaid facts, let notice be issued to respondent number 1A, 1B, 1D to 1H through the concerned police station, for which requisites be filed by the appellant within a period of 15 days from today. Within a period of 1 week from today. Let notice be served on this matter. But in one case, substantial question of law has not been framed. This is. Seventy. This is 73 में है, 74. कौन सा ऑर्डर सबमिटेड? सर एडमिटेड. अब 1 वीक में उसका रिक्विजिट फाइल कर दीजिए and then we will hear them. It's a very short question of law which is involved in all these cases, right? तीनों केस में आंटी अलाउड. हाँ, deleting party. एक में नोटिस जाएगा because some of the respondents, substituted respondents are not been served. Pose this case for final disposal on 14th of October, dated in the supplementary process.
Item 6, second appeal 189 of 2003.
Yes. Password. Who will come?
JJ Sanga, senior counsel.
Call in, please. 11:30. 11:30.
Item 7, second appeal 588 of 2004.
Lord, एक आई है
Or
for substitution of respondent number 10. Lord,
when did he die?
he died. He died 22/7/2025, and within time.
IA number 10802 of 2025. This petition has been filed for substitution of respondent number 10, who is going to have expired on 22/7/2025. The names of legal heirs and successors of respondent number 10 has been mentioned in paragraph 1 of the interrogatory application. issue notice to the legal heirs and successors, proposed legal heirs and successors of respond number 10. Through speed post. For which requisites be filed. Speed post is IM, interlocutory application, for which requisites be filed within a week.
Only if the speed post loads.
Only speed post.
Okay.
हो जाएगा ना
हाँ,
स्टैम्प
बिल्कुल, बिल्कुल।
ऑफिस टू टैक्स स्पीड पोस्ट
बिल्कुल, कल ही हम लोग करते हैं।
पोस्ट दिस केस ऑन डेफिनेटली है
सेकंड
क्या सब्सटेंशियल डेट व्हाट इज सब्सटेंशियल
पेंसिल क्वेश्चन लॉ आल्सो
यू आर रिप्रेजेंटिंग होम
प्लेंटिव लॉ
यू आर रिप्रेजेंटिंग होम रेस्पोंडेंट किसकी तरफ से वकालतनामा
ऑर्डर नंबर 4 लॉर्ड्स
ऑर्डर नंबर 4
whether the judgment of lower appellate court reversing the finding of the trial court on the ground of family settlement having been entered into in the year 1980 after the death of Gokha Devi cannot be given effect. This is the partition suit.
चलिए पोस्ट दिस केस ऑन
In I am my lords,
14th October
14
I am appearing on behalf of the respondent.
which respondent
जो फाइल की सब्स्टिट्यूट respondent बीना देवी, विनय पांडे, जो नागेश्वर पांडे के जितने भी लीगल एयर हैं,
सबकी
सब
तरफ से
जी सबके तरफ से वकालतनामा आया रिसीव में।
altogether there are 8 persons 8 लोगों का वकालतनामा है
जी आठों के
ओके तो अलाउ कर दें
जी
वकालतनामा फाइल किए हैं
नहीं आज कर देंगे।
ओके फिर से देखिए आइए नंबर 10802 of 2025 counsel for the appellant has submitted this petition has been filed for substitution of respondent number 10 who is said to have expired on 22/7/2025 leaving behind the legal heirs and successors whose details have been mentioned in paragraph 1 of the interlocutory application. Mr. Nandapai
मोहन कुमार दुबे
Mr. Mohan Kumar Dubey submits that he has received wakalatnama on behalf of all the legal heirs and successors whose details have been mentioned in the interlocutory application. He undertakes to file the wakalatnama during the course of the day. He has submitted that he has no objection so far as the interlocutory prayer for substitution is concerned. आपको कोई objection है? The learned counsel appearing on behalf of the other respondents also does not have any objection. Considering the facts, I number 10802 of 2025 is hereby allowed. The counsel for the appellant is directed to delete the name of the respondent number 10 from the cause title and insert the name of legal heirs and successors in red during the course of the day. The counsel for the proposed the counsel for the legal heirs and successors of respondent number 10 undertakes to shall file the wakalatnama during the course of the day. आज फाइल करिए
हाँ आज ही
अब आगे क्या करना है बताइए कब सुनवाई करना है इसका हो गया सर्विस कंप्लीट
इसी दिन तो मैं आई एम रेडी
नहीं सर
आफ्टर 2 वीक्स
और तो कोई नहीं बचा है इसमें
नहीं नहीं तैयार है कोई भी डेट रख दिया हम लोग तैयार है बस
with the consent of the learned counsel for the parties pose this case for final disposal on 17 September.
ओके
Item 8, second appeal 85 of 1994.
Yes. But the second appeal has been admitted. Sorry.
कब का है ये तो हमको 84 लगा
Then have not 85 है.
85 85 of
85 of
1994
94 है.
94
94.
बताइए
लेकिन
सब्सटेंशियल
कोई
क्वेश्चन ऑफ
तजुब का बात नहीं है, पुराना केस बहुत सारे सब पेंडिंग है।
नहीं हम लोग सारा लगवा दिए
अब होने लगे।
अब तो
सारा
वो
now
टारगेटेड केस का
everybody
जो
is- हाँ?
हेडिंग आ गया है, टारगेटेड केस वाला सारा
नहीं
पुराना
टारगेटेड
केस
केस
सब
के अलावा भी हम तो वैसे ही फॉलो अप करते हैं। अब हमको नहीं लगता है कोई केस आउट ऑफ सर्कुलेशन,
हाँ
अभी फिजिकल वेरिफिकेशन करवाएंगे तब पता चलेगा। लिटिगेंट को नहीं ध्यान है तो हम लोग को तो ध्यान देना पड़ेगा। बताइए क्या बोलना है?
और इससे कम से कम एक बेनिफिट बहुत हुआ है कि हम लोग को सबको इन्फॉर्मेशन पहले करके जो है जो भी वो सब हो जाता है, सो दैट कि हम लोग भी रेडी हो जाए।
इससे सबसे ज्यादा बेनिफिट ये हो रहा है कि फेस्टिवल बढ़िया से मनेगा।
सबके लिए हम लोग भी होगा।
डेफिनेटली
आई एम मोर कंसर्न विद दैट, फेस्टिवल बढ़िया से मनना चाहिए।
सबको दुर्गा पूजा बढ़िया समझ में दुर्गा पूजा भी बनी।
But there is one IM because it was admitted in the year 1995, no, 16/8/95.
Yes, I am on that also.
Yes,
Can you read it?
yes. Whether the inference drawn by the lower appellate court regarding the partition of the property between the plaintiff and defendant on the oral and documentary evidence regarding separate mess and cultivation between the co-sharer is legal, and as such inference is available under Hindu law, can be made available under the Muslim Mohammedan law also, and then liberty was granted. But the suit have been filed by the plaintiff.
And they are Mohammedans.
Yes, no. But I will just pass on the one of the logical table, which will help you.
No, we'll come to that. You see,
Yes, please.
you can give the background in 2-3 minutes, but we will read it from the interim judgment.
Yes, very well.
Case of the respective parties, we'll read from
But
the
I only want to point out one.
genealogical case. उनको दिए?
हाँ.
Is there any dispute in genealogy?
No, no, no. There's no dispute. But we have experienced that your lordship is only confining to question of law. Therefore,
Yes.
I have filed an IA for framing additional question of law.
What
Because-
is that additional
yes.
question of law?
So, note, I want to straight away come to that IA first. IA number 12148, note of 25.
Read what are the
Yes.
proposed substantial
Yes.
question of law?
But the proposed substantial question of law notes at whether the plea of previous partition set up by the defendant based on mere inference and without any proof of the same can disentitle the plaintiff from getting a decree of partition, whether in spite of clear-cut admission of the defendant in their written statement filed by defendant admitting that the lands of Khata number 36, 11 and 110 are joint family property and liable for partition, the suit of the plaintiff could have been dismissed.
Abhi?
Then note whether the lands of Khata number 80, 88, 89, 90 are joint family property as they have been acquired during the lifetime of common ancestor Sheikh Father, and there is no proof of any separate income oblique business of the business defendants from which they can acquire the lands of the said Khata, and from which it is evident that the
Do
aforesaid
you
lands.
want to file a response to this?
No, but we have not filed counter.
You file a counter. You want to file a counter?
कॉपी नहीं दी है
Because substantial question of law,
हाँ.
reason has to be assigned as per the recent judgment of the
Yes.
Supreme Court, and you have to be heard as per the provision of law.
Thank you.
So, by filing the response to this IA, I think your junior would do that. What are the findings? You just call out in short, right? Such that it is easy for us to gaze through the matter and then frame the substantial question of law, if any. Right? आप इनको भी दीजिएगा copy.
कॉपी करें.
आइए कितना टाइम चाहिए आपको?
10 days.
IA number 12418 of 2025. This petition has been filed for framing additional substantial question of law. The learned counsel for the respondents pray for and are allowed 10 days time to respond to the interlocutory application. Genealogy is in dispute.
No. Genealogy क्या dispute?
Genealogy में कोई
जेनरल
dispute
में
नहीं.
डिस्प्यूट नहीं
बड़ा बहुत. Correction.
Correction.
Dispute नहीं. नाम
और
और
नाम spelling mistake.
Oh, ठीक.
ठीक है?
इसमें ऐसा कोई
ठीक
dispute.
है. A family tree has been provided by the direct counsel for the applicant, a copy of which has been served upon the respondents. As it appears as of now, there is no dispute so far as the genealogy is concerned. The response to the interlocutory application be filed by 22nd,
Yes.
post on 24th.
Yes.
24th को होगा तो करेंगे, नहीं तो आईए पे जो ऑर्डर करना है करेंगे, उसके बाद फाइनल डिस्पोजल के लिए हम लोग
Yes.
छुट्टी बाद next.
Lords, 24th we decide this IA. for the
Yes,
question.
yes. First we will decide this आइए,
Yes.
और अगर हम लोग को रिजेक्ट करना होगा तो भी फाइनल हियरिंग के लिए आई पुट अ डेट, छुट्टी
After-
के 2 दिन पहले हमको इस तरह से फाइनल डिस्पोजल का मैटर नहीं टेक अप करना है.
Because Lord, last night I went through all these and I pointed out, Lords, in my question of law IA at what is the relevant paragraph of the judgment from which I want to.
वो थोड़ा सा
Highlight.
प्रिपेयर कर लेंगे तो
हाँ,
आराम
उससे
से हो
आसान होता है
जाएगा.
Lords, क्योंकि
नहीं तो पूरा हियरिंग करने के बाद पता चलेगा, then it will be waste of time for 1 hour at least. Right?
Item 9, second appeal 39 of 1995.
Yes, applicant.
Yes. Actually, this case, Lord, has been admitted by this honorable court on
So
three.
service is complete.
Complete.
Parties are appearing.
I have here.
Yeah, very good. Time must find please. Don't play for time.
Only minute.
हमको देखने से पता लग जाता है अब टाइम कहाँ है.
खाली next week.
95 का मैटर हम नेक्स्ट वीक नहीं रखेंगे.
थोड़ा सा.
नहीं हम कुछ नहीं. हियरिंग शुरू करते हैं. Respondent number 1 का substitution नहीं हुआ है ना? Respondent number 1 अबेट कर दिया है क्या? नहीं, नहीं substitution बाद में आया है. Let me just check. बताइए क्या है?
Yes. Lordship, may kindly see order dated 3/1/1996, Lordship. The substantial question law has been framed by the honorable court.
Yes.
Whether the court below has erred in holding the partition by metes and bonds amongst the parties on the basis of entries in the record of right, wherein some parties recorded jointly as well as separately in the names of the parties, Lordship. Record of right में किसी प्लॉट पे joint लिखा हुआ, किसी में separate लिखा हुआ. But law is said that the separate means and separate position is not a conclusive proof of party. I will show, Lordship. Doctor, may kindly see para 2, Lordship, the fact of this case, Lordship. The judgment of learned trial court, Lordship, para 2. From the plaintiff, the case of the plaintiff appears in short is that plaintiff and defendants are the members of joint Mitakshara family and they are governed by Mitakshara school of.
Just yes. सर आपके पास फाइल है ना? बैठे. छोटा सा पॉइंट है सर, लॉ सेटल्ड है. लॉ इज सेटल्ड. कितना पुराना केस का क्वेश्चन ऑफ लॉ का बहुत सारा चीज सुप्रीम कोर्ट से सेटल हो गया है.
पटना हाई कोर्ट के जजमेंट हमने.
अच्छा.
Concurrent finding है दोनों कोर्ट का.
हाँ देखते हैं हो सकता है डिसमिस कर देते. सर कॉन्करेंट फाइंडिंग है दोनों कोर्ट का. There is a substantial question of law. Your argument that this is not a substantial question of law, यही बोलिएगा concurrent finding है, correct? Now we will see what is the consequence. We will record your submissions to that. Is that okay? ठीक है ना? थोड़ा देर से करना चाहते हैं, थोड़ा देखना चाहते हैं फाइल, तो हम 1 बजे के लिए कर देते हैं. आपके पास 1.5 घंटे टाइम.
Honest है, कम से कम day after tomorrow कर दे.
ऐसा
Tomorrow कर दे.
नहीं,
तब
1 बजे कर दें.
नहीं अभी कर दे.
ठीक, चलिए.
Para 2, Lordship, facts of the plaintiff's Lordship. From the case of the plaintiff appears in short is that the plaintiffs and defendants are members of joint Hindu Mitakshara family and they are governed by Mitakshara school of the Hindu law and Hindu Succession Act 1956 in the matter of partition and succession. It has further been stated that suit property are the joint family property both the parties. One Khudia Mato was the common ancestor of the both the parties who died before CS, leaving behind his two sons Raghunath Mato and Baiju Mato, who were recorded in CS record of right jointly in respect of some plots and separately in respect of some other plots of the suit land. Further case of the plaintiff is that Raghunath Mato was the eldest son of the Khudia Mato and he was Karta of the joint family. After death of Khudia Mato, cadastral record was prepared at the instance. Thereafter, both the Raghunath Mato and Baiju Mato died before RS operation. Raghunath Mato died leaving behind his son Chamru Mato, Balka Mato, Dhirja Mato, while Baiju Mato died leaving behind his son Ganesh Mato and Paresh Mato. And Paresh Mato also died before RS, leaving behind his son Binda Mato. And RS record was prepared jointly in respect of suit property in the name of heirs of Raghunath Mato and Baiju Mato. Some of the land were recorded jointly while some were recorded separately in the name of sons Raghunath Mato. Since the sons of Raghunath Mato was elder and Chamu Mato was being eldest son of the Raghunath Mato was the Karta of the joint family consisting the sons of Raghunath Mato and Baiju Mato. Further case of the plaintiff is that in course of time sons of Raghunath Mato, Baiju Mato died one after another, leaving behind their son. Plaintiff and defendants as their legal years shown in the genealogical table attached with the plaint. Chamu Mato died leaving behind his only daughter Hasni Devi, who died during the trial, leaving behind her husband Bhasiya Mato. Balta Mato died leaving behind his one son Doman Mato, his wife Musmat Gurubari, and one daughter Mini Devi, while Dhija Mato died leaving behind his wife Musmat Sukrabari and sons Sivnath Mato, Devnath Mato, Ram Ratan Mato, Jai Singh Mato, and two daughters of Sabi Devi and Urmila Devi, while Ganesh Mato died leaving behind his son Hariyar Mato, Govardhan Mato, and two daughters Susila Devi and Purni Devi, and plaintiff number 1 to 4. Binda Mato died leaving behind his son, two sons Lohra Mato and Duraj Mato, and two daughters Jaleswar Devi and Panchami Devi, who are the plaintiff number 5 and 6. The heirs of the late Raghunath Mato are the defendants in the present suit. Further case of the plaintiff is that after the expansion of the family, mace and cultivation of some land being done separately for the sake of convenience, but family land and property are still joint, and there have not been any partition among the family members by meets and bonds. Recently, some of the defendants have become dishonest and they are raising unnecessarily dispute in the matter of cultivation of the joint family property. Hence, the necessity of the partition by meets and bonds arose, and plaintiff have requested the defendant for partition of joint family property by meets of bonds in the month of May 1985. But the defendant at the first instance agreed, but later on avoided and requesting this suit. The defendant number 1, 2, 3, and 5 to 9 appeared and contested the suit, while the defendant number 4, 10, and 11 did not appear to contest the suit. Hence, the suit was heard ex parte against them. From the WS of the contesting defendant, the case of the defendant appears in short is that plaintiff has no valid cause of action for the suit. They have shown imaginary cause of action for the present suit. No such cause of action as alleged ever arose. It has also been stated that suit is not maintainable. Actually, this is a pure suit for declaration of title in the garb of partition. It has been stated the suit is barred by law of limitation, adverse possession, ouster, as well as the principle of ever equivalence. The court fee is also paid insufficient, and ad valorem court fee is required to be paid. The suit is also bad for misjoinder of defendant number 2, 4, 10, 11. They have been unnecessarily implemented party. It has also been stated that plaintiff have not given any particular land in this schedule. Further case of the defendant is that there is no unity of title possession among the parties. Ancestor of the parties have partitioned the land of Khata number 2 of the village Navadi along before the CS. According to that partition, it was so recorded CS Khata number 8 according to their respective shares. In the RS also recorded recorded according to their shares in RS Khata number 2. So far, RS Khata number 168 of the village Paria D is the concern. It is not ancestral property of the parties. Rather, these lands are acquired by late Raghunath Mato the ancestor of the defendant alone by exchange with the Abhiram Mahato, who was landlord of the village in lieu of the Raghunath Mahato's on Rayati land of Khata number 54 of village Nawadi. Said Raghunath Mahato exchanged his land of CS Khata number 54 in exchange of CS Khata 273 of the Abhiram Mahato, and heirs of Raghunath Mahato so recorded in the RS Khata number 168 of village Periya, while the in RS Karam Singh Mahato, son of Abhiram Mahato, was recorded exchanged the land of CS Khata number 54, RS Khata number 81, CS Khata 273, which was given in exchange by Abhiram Mahato, was resumed by him after the death of recorded him without any issue. Further, the case of the contesting defendants that since then the defendants also dealt with the land of their Khata number 2. They have exchanged plot number 254 with the Rameshwar Mahato and other of village Nawadi. It has also been denied that Raghunath Mahato was the Karta of the joint family and Chambu Mahato was the Karta of the joint family. Thus, the ancestors of the parties have already partitioned their land long before the CS, and they are holding the land according to that partition. Hence, the plaintiff have no share in the suit land. Thus, the plaintiff have no valid cause of action for the suit, and thus the suit is to be pushed. Lordship, may I see the
Issue number 4 and 5.
4 and 5, the findings para.
These are the only issues relevant?
Yes, only notes.
Okay. Genealogy is in dispute?
Yes, no dispute. Para 5 notes the findings, issue number 4 and 5 notes. In the suit, first of issue number 4 and 5 will be taken together for consideration. These are most important and interlinked with each other in the suit. Plaintiff has issued the suit for decree of partition their half share in the suit property on the ground that plaintiff and the defendants are member of the joint family and partition has not been taken place as yet by means and bounds. However, they have admitted that they are the separate cultivating position over the same portion of the suit land according to their convenience, and some portion of the suit land are still joint. On the other hand, the case of the contesting defendants are that the plaintiff and defendants are member of the same family having common ancestor or partition has already been taken place in the family long back, even prior to cadastral survey. Since then, the party are coming in separate possession and separate cultivation, separate mess and separate dealing their affairs separately. Hence, the only point for consideration or decision in the suit whether the family of both the parties are still joint, they are unity of title and possession between them in respect of suit land, so the partition has already been taken place in the family as claimed by the defendant. In the suit is admitted by both the parties they are Hindus and governed Mitasa School of the Hindu law and Hindu succession at 1956 in the matter of succession is related. Genealogy table of the family as stated in the play already been admitted. According to their genealogy, Khudiya Mahato was the common ancestor of both the parties. He died leaving behind his son Raghunath Mahato and Baiju Mahato before the CS record. In CS record, property were recorded in the names of Raghunath Mahato and Baiju Mahato, some jointly and some separately. Raghunath Mahato died leaving behind his 3 sons and Baiju Mahato died leaving behind his 2 sons, out of which one Paresh Mahato has also died leaving behind his only son Binda Mahato. Thus, record of right in RS record was prepared in the name of 3 sons of the Raghunath Mahato and 1 son and 1 grandson of the Baiju Mahato. Now, the plaintiff of the present suit are from the branch of the Baiju Mahato and defendant from the branch of Raghunath Mahato. In support of their case, both the parties
The
have
defendant are from the branch of Raghunath
Mahato.
लेकिन यहाँ क्या लिखा हुआ है? रघुनाथ में तो
नहीं वो गलत
लिखा है.
गलत लिखा
But
actually
yours are late Raghunath Mehto are the defendants in the present.
defendants.
Okay. Carry on.
In support of their in support of their respective case, both the parties have adduced oral and documentary evidences on these issues. First of all, documentary and oral evidence of the plaintiff will be taken for considering this suit. The suit property is 3.97 acres of land of RS Khata number 2 of Northern Nawadi and 2.87 acres of land RS Khata 168 of the village Peradi. Plaintiff has exhibited CS survey Khatiyan of Khata number 8, 5 and 54 of the village Nawadi and exhibit 3 series which shows that Khata number 5 of the village Nawadi has been prepared in the names of both the Raghunath and Baiju Mahato, sons of Khudiya Mahato, showing equal share. It consists of these Khata 3 plots, plot number 95, 234 and 292 in the vast column of the plaintiff, plot number 95. The possession of Raghunath Mahato has been shown, while the remaining in 2 plots, the possession of 1 Sarakar has been shown. Khata number 5 has been recorded in the names of Elon Baiju Mato, and Khata number 54 has been recorded along in the name of Raghunath Mato. The plaintiff has also examined survey knowing pleader commissioner Sri Jagnandan Pandey, who has compared the CS survey plot corresponding RS plot. He admitted that his report has been marked as Exhibit 2. The plaintiff has further exhibited the CC of the record of RS Khata number 2 and Exhibit 4. From the perusal the report of the Pleader Commissioner, which is Exhibit 2, it appears that CS plot number 95, 234, 272, 292 has been recorded in record over at 93, 361, 399 and 384 of the RS Khata number 2 in the name of Chamu Matu, Balku Matu, Dhigo Matu, who are the sons of the Raghunath Matu, and Ganesh Matu, Binda Matu, sons of Paresh Matu, but in the remarks column, possession of Chamu Matu and Balku Matu, sons of Raghunath Matu has been recorded. Similarly, plot number 22, 23 and CS Khata number 5, which was recorded in the name of Baiju Matu alone, has been recorded plot number 70 to 73 in RS record number 35 and 89 of RS Khata number 2 in the remarks column. The possession of the Ganesh Matu and Binda Matu has been shown, who were from the branches of the Baiju Matu. While the CS survey plot number 86 and 87 of the CS Khata number 54, which are not suit land in the respective suit land, have been recorded in RS record number Khata number 78, 79, 80, 136, 137, 138, and 139. The learned lawyer for the plaintiff argued that CS Khata number 8 was recorded in the names and interest of both the parties, and RS Khata number 2 has also been prepared in the names of interest of both the parties, which shows that disputed land was joint property of the parties. The plaintiff has further exhibited CC of the record right in RS Khata number 165 of village Peradi as Exhibit 4 by A, which has been recorded along in the name of Chammu, Balku Mato and Dheeraj Mato, all sons of Raghunath Mato, which consist of many plots and separate possession of each. The recorded tenant have been shown in the remarks column. The plaintiff have further exhibited Exhibit 5 and Exhibit 5A, which are survey maps of the village Mauja Nawati. The plaintiff have also exhibited one rent receipt granted 1811-85 Khata number 2 in the name of Binda Mato for 3.97 acres of land. Exhibit 1 is shown the rent of Khata number is still being paid by the parties. So far as oral evidence of the plaintiff is concerned, they have exhibited as many as 6 witnesses, out of which PW1 Chammu Mato of village Somodu has stated about the genealogy of the parties, has stated that Baji Mahato and Raghunath Mahato both were brother of the Raghunath Mahato, were the Karta of the family. He further stated that there was no partition meets and bonds in between the brother, and they were cultivating the land according to their convenience. He further stated that he heard that no partition has been taken place among both the brother and they were jointly, but he has admitted that this he heard from the ancestor of the plaintiff. Hence, from the examination in chief, he has admitted that he is not definite about the jointness of the parties. However, according to him, the ancestor of both the parties were cultivated separately. In cross-examination, he also admitted that the Persian parties are cultivating the land which was previously cultivated by their ancestor. They are cultivating separately, having their separateness. Not only this, he has also admitted that all the parties are dealing the land separately. In this cross-examination, he is unable to say about any of the suit land. Similarly, PW2 Sorai Mato is the resident of village Nawadi and same village in which the party is residing. He has stated that about the genealogy of the party. He stated that according to his knowledge, the suit land has not been partitioned between the parties, but in cross-examination, he stated that he has no definite knowledge as to whether there is any partition between the Raghunath Mato or Baiju Mato. Has been taken place or not, but he has admitted that defendants of each brothers are residing separately in maize and cultivation. They are also dealing separately. Hence, from the evidence, it is clear that it is not the complete witness to say whether there was any partition in the family of the party. Moreover, he has not clearly denied the suggestion of the defendant the partition has already been taken place in the family. PW3 is Banwari Mahato of village Elahati. He has in land nearby one of the disputed land. He has stated the suit land is the ancestral land of the party. They are cultivating according to their convenience. But in cross-examination, Parana, he admitted that both the parties have separate mess, having separate business and dealing. He also unable to say as to over which the portion of the land each party in possession. Though the witnesses claim that he has cultivated the suit land on behalf of the plaintiff, but he is unable to say the details of the land. PW4 is the formal witness who exhibited the rents received, Exhibit 1. PW5 survey knowing Federal Commission has compared the corresponding of CSRS plot. PW6 is the Harrier Mato, who is the plaintiff number 1 himself in examination in chief. He supported his case, stated that both the parties are members of joint family. No partition by meets and bonds has yet been taken in the family. He has also stated Raghunath Mato and his wife's son Jambu Mato were the Karta of the family at the time of CS and RS. They also got recorded joint land in their name. He further stated that they are still cultivating the land according to their convenience and having their separate mess. But in cross examination, he admitted that both the parties are living separately in mess and cultivating over the land which their ancestors were separately cultivating since his childhood. On the other hand, the defendants have exhibited Jamindari rent receipt Exhibit 4 series, which is the respect to RS Khata number 168, which has been granted in the name of Doman Mato, who is the son of Balka Mato and Teja Mato. Are from the branch of Raghunath Mato. They have also exhibited the rent received land of Mauja Nawadi, for which the receipts has been granted in the name of Chamu Mato.
Both the parties were showing documents to show, and ultimately some of the land was recorded jointly.
And some of the separately.
Some recorded separately, but separate possession and cultivation and mess was also shown.
So,
Right?
yes, this is the very small point. But the Honorable Patna High Court held that the separate mess and separate possession is not a conclusive proof of partition, not say.
Not a conclusive proof, but the court has not taken it as a conclusive proof.
They have taken conclusive proof. They have
Let's see
taken.
the finding, para number 10.
Para number 10. Yes. From the oral and documentary evidence of both the parties as discussed above, it is apparent that both the parties are separate in maize cultivation dealing. Documents filed with the plaintiff and defendant show that some lands were recorded separately in the parties in the both CS and RS operation. The record of right का ही findings आया है.
No, not only that. There is no dispute that they were separate in mess.
Yes.
There is no dispute that they were separate in cultivation.
But
इसमें तो कोई dispute नहीं है.
नहीं, इसमें कोई dispute.
इसमें कोई dispute.
कोई dispute नहीं. पढ़ रहे हैं आगे. This shows that there was a partition. There was partition. The parties are living separately. Not only both the parties have been recorded separate keywords and they have been joined. There was no question of opening separate keyword in their name so far as oral evidence is concerned.
नहीं, एक सेकंड, सेपरेट keyword कैसे बनाएंगे नाम से?
नहीं, सेपरेट तो नहीं बनेगा ना.
नहीं बना ना, बना है. तो सेपरेट keyword बनने का क्या मतलब है? There has been some partition.
The record of right is not a document of title or document of partition law.
They are not saying that record of right से किसी का title create हो. Their contention is that there was a partition and the properties were separately recorded in the keywords. It is not a case somebody is transferring the right title interest by virtue.
I am also not saying that transferring the right title interest.
So the court is drawing a conclusion that there is separate keyword prepared with respect to the parties, right?
No. Record of right was recorded in the name of Raghunath Mato and Baiju Mato Lordship.
Separate keyword का भी कहानी.
Keyword.
Defendants have brought on record many keywords which shows that they were separate, right? They were, you see, Exhibit E, which shows that keyword number 17/3 has been recorded in the name of Binda Mehto. 17/4 was recorded in the name of Ganesh Mehto. 17/5 was recorded in the name of Dheeraj Mehto. 17/6 has been recorded in the name of Chama and Balka Mehto. This shows that both the parties were recorded separate keywords, right?
But separate keyword does not show the partition lordship.
You see, in the case of partition, oral partition is also permissible.
Correct.
So what would be the evidence to come to a finding as to whether they were separate or not? whether the partition had actually taken place or not.
Or not.
Right? There are cases that the partition had taken place prior to CS survey. So they are demonstrating the partition by oral and documentary evidence. And you are also disputing the partition by oral and documentary
And oral and documentary
right?
evidence.
So they are showing this table. The court is drawing an inference from these separate recordings of Khevat's that this indicates that there was partition between the parties.
But the separate Khevat is not a proof of the partition, Lord.
Not a conclusive
Not a conclusive
but
proof of the
certainly
partition.
it is a material proof, material document for consideration.
But the learned trial court discarded the evidence of the plaintiff.
No, let us see what happened thereafter.
Yes, Para 10, Lord.
आगे क्या finding?
Para 10 से ही पढ़ रहे हैं findings शुरू
हाँ
होगा.
पैरा 10 वही पर
From the oral as well as
नहीं
document.
उसके नीचे आइए ना we are already read it. So far as oral evidence is concerned last time
Last. So far issue number para 11, Lord.
नहीं पैरा 10
Para 10, Lord.
पैरा 10 internal page 12 last time
Last. So far the oral evidence is concerned, then even evidence of the witnesses of the defendant. Leave aside all the witnesses of the plaintiff have admitted that both the parties are separate means cultivation and dealing. In course of argument, learned lawyer for the plaintiff submitted in CS operation khata number 8 was recorded jointly in the name of Raghunath and Baiju Mato, the ancestor of the present plaintiff and defendant. And even in RS operation khata number 2 of Mojan Nawadi has been recorded in the name of ancestor of both the parties.
आगे
Which shows that both the parties are joint and there was no separation by means and bonds in the family. He also argued that it is a presumption the Hindu family is the joint and the party claiming partition in the joint family has to prove the partition by the definitive cogent evidence. But in the present suit, defendant have not been mentioned any date of partition. He merely the parties are in the separate possession of the land and separate means. Due to convenience, it cannot be said that there was a partition by means and bonds in the family. Another learned lawyer for the defendant argued that no doubt it is the presumption the Hindu family is joint unless the partition is proved, but the presumption becomes weaker and weaker due to lapse of the time generation to generation. When it is proved, as in the present case, the parties are separate in means, cultivation and dealing with which even admitted by the witness of the plaintiff from the time of the ancestor of the party, it is not necessarily not possible to say exact date of partition. Rather the partition evidence will be gathered from the conduct of the party and circumstances of the case. In the present case, the admittedly parties are in the separate means, cultivation, dealing, having no concern with each other. They have recorded separate Khevat in RS operation and separate land both the CS and RS operation, showing their separate position in the Mars column. Hence, merely record of right has been recorded in the joint names of the ancestor of the party, not enough to show the parties are joint. The argument advanced by the learned lawyer of the defendant find support from the evidence of the defendant and appears more convincing. In the present case, evidence both the oral and documentary as discussed above, as well as from the facts and circumstances of the case, it appears the parties have already been taken place in the family of both the parties, even prior to CS cadastral survey. Since then, the ancestors of both the parties are living separately in maize cultivation, dealing. There is no unity of title and possession between the parties. Hence, both the issues are being settled in favor of the contesting against the defendant. Appellate court भी confirm किया same जी. Although lordship the points have not been framed, lordship. The findings is
para number 12.
Para number
The point for determination is there.
para number 2.
The only question to be determined.
Para number now, therefore, in the appellate court, only question to be determined whether there had been previous partition between the parties indicated and evident by the cause of conduct during that period of time elapsed before the CS record when the instance suit was instituted. And findings, lordship. 1920 lordship, this is the finding.
1920 में मत आइए, आप इसको पढ़िए.
For 18. Para 18 top. Para 14 was there. Now during the regional survey operation, although RS Khata number 2 is shown to be jointly recorded in the name of Chanu Mathu, Dalki Mathu, Dili Mathu, served with Raghunath Mathu, Bindu Mathu, Paresh Mathu, Dinesh Mathu, Baby Mathu, two position of the Chanu Mathu, Balipu Mathu, and Birja Mathu have been shown jointly over 2.4 acres of land, whereas the position of Ganesh Mathu has been shown 1.1 acre of the land, and position of the Bindu Mathu has been shown over 0.92 acres of land. Possession over all these lands have been shown separately. Thus, the total area shown
पोजीशन सबका सेपरेट दिखाया है, जॉइंट नेम से होने से क्या हुआ? पोजीशन सबका
separate. Separate.
तो पार्टीशन का है ना एविडेंस है
According to it is not a partition law. I will show the judgment.
जजमेंट जी आपका ड्यूटी कब चेंज होता है? कितना बजे? आप जाइए 15-20 मिनट हमको लगेगा, आप अपना काम करिए, ठीक है? और जो भी जिसका ड्यूटी है नेक्स्ट उनको भेज देंगे।
Note the mechanism first 2000 volume 2 PLGR page 522 para 11 notes. बता
लेट अस सी एक सेकंड, ये सेकंड अपील से आ रहा है।
जी
ये फर्स्ट अपील है,
ये हाँ फर्स्ट अपील लॉर्ड्स
ये फर्स्ट अपील।
first para 11 lordship and time to I have marked the lordship. ये ना para 8 का देखा जाए, sorry page 8 lordship और मार्क किए हैं. Partition should their separation of parties in mess and business cannot be treated as a proof of complete partition lordship.
नहीं ऐसे हम जजमेंट नहीं पढ़ते हैं, आप पैरा नंबर 10 से पढ़िए
Para number 10.
and read it full text.
Thus, it appears that large number of documents have been filed. So far as the document on behalf of the plaintiff are concerned, some rent receipts have been filed in order to show that rent receipts were granted jointly. On the other hand, the rent receipts have been filed on behalf of the defendant so that rent receipts were granted separately also. Further, the defendant have submitted that Jamabandi was not split and no such paper has been produced to show that there was an order of splitting up the Jamabandi after the partition. However, from the entire evidence, it appears that though there was no formal partition between the parties were dealing with the property separately from time to time. Many of the acquisitions have been made in favor of the different defendant, mostly in the favor of the defendant number 1, Suklal. So far as plaintiff was concerned, they alleged that Suklal was the karta of the family and he was making this acquisition from the joint family property. So far as the existence of the property is concerned, there cannot be any doubt about it that family had nucleus and some acquisition was made before the party was classified by them. The existence of the sufficient nucleus is not in dispute, but the main question is whether these acquisitions were made separately by the party. It appears that it is admitted case that Suklal was in the service at Bihata and he had some personal income. It also appears that family was pursuing their business and cultivation separately. Through there was no formal partition. The learned trial court has held that the plaintiff had failed to prove the jointness in the family. Therefore, in spite of fact, there was no convincing evidence on behalf of the defendant showing partition of the property as claimed by them. Learned trial court has refused to accept the plea of the plaintiff regarding the continuance of jointness. In this connection, it has been rightly submitted on behalf of the appellant that so far as question of owners is concerned, the Hindu law there is a presumption of jointness between the close agent It is duty of the party who claim the partition to prove this fact, but the learned trial court has not approached this issue from this point of view. It is true that there is presumption of jointness in Hindu Mitaksha family, but at the same time, it is also clear that presumption of jointness becomes weaker and weaker with the passage of time. It is obvious that presumption of the joint between the brothers is greater than presumption of jointness between the two cousin brothers or second cousin brother. In the present suit, there is no dispute about is that both the parties are descendants of the two brothers, namely Tulsi Yadav and Gopi Yadav. And suit has been brought by the grandsons of the Tulsi Yadav against the grandson of the Gopi Yadav. Therefore, it cannot be said there is a certain extent of presumption of jointness between the parties and separate in this case. It is very natural that by passage of time there was a disruption in the family. Therefore, the standard laid down by the Hindu law is that if parties do not partition their property by means of bonds or the registered document of filing a suit or obtaining a decree for partition, they divided their property amicably by agreement if there is intention on the part of the party to the party. There is a disruption in the family and jointness cannot be treated with this time. In the present case also, though the defendants have failed to prove there was a partition in a joint family at a particular time, a particular year, in particular manner, it appears from the evidence of the plaintiff themselves as observed by the trial court, the family had their separate business and one had nothing to do with the affairs of the other. It is therefore clear that there was a division of the property to some extent that the different branches might have been cultivating theirs separately according to their convenience. But there is no evidence of complete partition merely because of Chowkidari receipt has been granted separately or the canal purchase had been granted separately or event rent has been paid separately. It cannot be said that it was a complete partition. Therefore, the finding of the learned trial court does not appear to be correct because it appears the parties were having their separate mess and separate business. It will be treated as a case of complete partition by means and bonds. The defendants have failed to state as to what separate residence occupied by them, which residence occupied by them plaintiff. It shows that though they might have been running their maize separately or might have been cultivating their land separately, there was no complete partition in family which cannot be termed as a partition by means and bond. So far as the acquisition as concerned, it appears that Suklal was the private service, was having some income. He had also shared in the family property. Therefore, it is not the strength that he purchased some property from the personal income. He had nothing to do with the plaintiff. Therefore, so far as separately acquired the property of the defendant, schedule in detail in schedule 2 are concerned, this property cannot be partible property, but so far as property of schedule is completely obvious, there was no partition by means and bond. If the partition is affected, it is the interest of the both of party. Otherwise, there may be confusion as to which the property belongs to which party. It is so because there is no document in existence to show that a particular land was attached with a particular party. Certainly, the mode of partition has not been disclosed by the defendant, whether the partition was through intervention of the punch or through the memorandum of partition or through the decree. In the partition suit, their separation of parties in the mess and business cannot be treated proof of complete partition.
जजमेंट आपके अगेंस्ट में क्या आपका फेवर
तो मेरे फेवर में
लाइक तो नहीं
नहीं मेरे फेवर में and another judgment lordship, another judgment with lordship. 1991 PLJR 199 para 13 and 14 entry in the revenue report. ये डायरेक्ट जजमेंट है हमारी para 13 lordship.
1955 Patna 408. समझिए 1955 Patna 408. This is arising out of a title suit, partition suit.
Partition. No. Plaintiff filed a suit for declaration of right title interest over the suit land.
It is a partition. It is a title suit.
Title suit.
Yes, title. You see, so far as title suit is concerned, the entry in record of right will not create any title. But when it comes to partition, there are joint owners of the property. Then under such circumstances, if one or the other entry is made in favor of one or the other party,
Yes.
show me one property amongst all the properties which has been held to be joint. which can be held to be joint.
Lots.
There is none of the
Yes.
properties.
Yes.
बताइए.
Correct.
RS खाता में joint name से है, लेकिन separate possession provided. कहाँ से?
नहीं होगा.
नहीं होगा ना?
नहीं होगा.
जब separate possession provided है, तो it shows partition. But under such circumstances, how is substantial? And essentially, this substantial question of law is rightly pointed out by him. It is not a substantial question of law in the eyes of law. It is absolutely fact-based. और ये जो जजमेंट आप साइड किए हैं, इसमें वो सब बोला है कि कोई एग्जैक्ट डेट देना जरूरी नहीं है.
यहाँ भी एग्जैक्ट डेट नहीं है.
नहीं है ना, तो दैट द जजमेंट व्हिच यू हैव
नहीं बोलना
साइटेड.
है, देना है. ईयर वो सब नहीं लिखा हुआ है.
नहीं, प्रिंसिपल ऑफ लॉ पे दिए हैं
हाँ.
कि जरूरी नहीं है देना. प्रिंसिपल ऑफ लॉ पे बोले हैं कि जरूरी नहीं है देना. And with the passage of time, the presumption of jointness becomes weaker and weaker. This is the ratio of this judgment. But in this particular case, certain rent receipts were jointly granted. Certain rent receipts were separately recorded. So there were some properties which was apparently joint. But in this case, there is no such property which is joint. Copy? बताइए. हाँ, रेस्पॉन्डेंट बताइए क्या बोलना. एडजमेंट चाहिए. अब एडजमेंट नहीं चाहिए ना. पढ़ी.
17-18 में सब जो बोल रहे हैं 2000 से
सेपरेट नोट है. आप ऐसा करिए, ट्रायल कोर्ट का जजमेंट तो ये फुल टेक्स्ट पढ़े ही थे. राइट, द रेलेवेंट पोर्शन. आप एपिलेट कोर्ट का
एपिलेट को हम 17 से पढ़ रहे हैं कि पूरा ही पढ़ा.
एपिलेट
कोर्ट का
एपिलेट कोर्ट का जजमेंट. एक सेकंड रुकिए, कहाँ से पढ़ना है बता.
15 से
12 से तो इशू फ्रेम हुआ है.
14 से.
ठीक है, 14 से.
14 से.
लेट अस read it.
Now during the revision survey operation, although RS Khata number 2 Exhibit 4 is shown to be jointly recorded in the names of Chamu Mahato, Balka Mahato, Dirja Mahato, sons of Raghunath Mahato, Binda Mahato, son of Paresh Mahato, Ganesh Mahato, son of Boji Mahato, but possession of Chamu Mahato, Balka Mahato and Dirja Mahato have been shown jointly over 2.04 acres of land, where as possession of Ganesh Mahato has been shown over 1.01 acres of land, and possession of Binda Mahato has been shown over 0.92 acres of land. Possession over all these lands have been shown separately. Thus, the total area shown to be in possession of the descendants of Boji Mahato is 1.93 acres. These persons, Ganesh Mahato and Binda Mahato, are descendants of Boji Mahato, which indicates that the son of Boji Mahato had also partitioned the lands of Boji Mahato and have been in possession separately to the extent of 1.01 acres and 0.92 acres respectively. From the above entries in both CS and RS record of rights, it is evident that not only Raghunath Mahato and Boji Mahato were separately holding and possessing their respective shares of land, but their sons also, after their death, possessed the said lands separately. So it is evident from survey record of rights that both the parties have been separately possessing the same blocks of lands of their respective shares for more than 90 years. So, from this course of conduct of the parties to the suit land and the course of conduct of their ancestors, it can safely be held that there had been partition since before CS, even though specific document of such partition is not available on record. DW1 in para 1, 2 and 4, DW2 in para 7, DW3 in para 2, DW6 in para 1, 2 and 4 have stated that both the parties were in separate possession over their respective lands, that they are separate in mass, residence, cultivation, and dealings. Similarly, PW1 in para 6, PW2 in para 6 and 13, PW3 in para 1, PW6 in para 22 have stated that parties are in separate cultivation possession in respect of the same land which were being cultivated by their respective predecessors in interest. These oral evidences also prove
Previous partition.
previous partition. The contesting defendants have produced CS Khata number 229 and 330 Exhibit D/2 of village per ID showing separate record of right of Bojima as his Bakast and Vermajurua land. They have also produced CS Khata number 231 and 232 which are exclusively recorded in the name of Raghunath Mahato alone as his Bakast and Vermajurua land. These exhibits prove the facts that Raghunath Mahato and Boji Mahato had got their separate land even prior to cadastral survey. These lands have not been brought in common hodgepodge in the instant partition suit. The contesting defendants have also filed the count of revisional survey Exhibit E to show that the parties to the suit have also got other lands recorded in Exhibit E, count number 17/3 to 17/6, to show that the parties have got their separate lands also. The learned lawyer for the plaintiff's appellant has vehemently argued that the contesting defendants have not produced any oral evidence to show that the partition had taken place in their presence at a particular point of time. The learned lawyer for the contesting defendants has, on the other hand, submitted the partition had taken place at such a remote point of time that it cannot be accepted that persons before whom the partition had taken place would be living at this point of time. In such circumstances, the entries made in the record of right and codes of conduct of the parties have got to be considered to show that partition had already taken place before the cadastral survey. The contesting defendants have also produced registered exchange deed Exhibit B dated 6/7/85 showing separate dealing of the parties in respect of their separate lands. This deed is of prior to the date of filing the suit. The learned counsel for the respondent relied on AIR 1991 Partner 95. Their lordships observed in the instant case not only before the CS settlement operation, the parties are in separate possession, separate mess, separate residence, and separate cultivating possession of the lands in question. There had also been separate dealings of the property amongst the plaintiffs inter se. Therefore, the conclusion of the trial court that there had been no partition by metes and bounds, and as such, the plaintiffs were entitled to degree of partition was illegal. Now, with regard to the lands of RS Khata number 168, the case of contesting defendants is that Raghunath Mahato had separate Kaimi land in village Nawadi. It is recorded as such in CS Khata number 54, Exhibit 3/B. CS record of right was finally published in 1905. The possession of Raghunath Mahato with regard to land of CS Khata number 54 was shown as Vermajurua for the last 6 years. This means that although Raghunath Mahato was in possession for 6 years, yet he had acquired the status of occupancy right. Therefore, he had been recorded as Gwair Dakhalkar, that is as non-occupancy right. It was not the ancestral land but a self-acquired one. According to contesting defendants, Raghunath Mato exchanged the land of CS Khata number 54 of village Nawadi with lands of CS Khata number 273 of village
That's why we
Baraji.
have seen it. That's all. There is. इसका detail है, पंकज। मेरे को देख। the learned counsel is appearing on behalf of the parties. This appeal has been filed against the judgment dated 17th of June 1995, giving back to the decree signed on 23/6/1995, that close, passed by learned 4th Additional Judicial Commissioner Ranchi, entitled appeal number 97/91/TR number 33 of 92, affirming the judgment and decree dated 13/9/1991, passed by learned subordinate Judge Khuti in partition suit number 248 of 1985. The learned trial court had dismissed the partition suit, and the judgment of the trial court was confirmed by the first appellate court. Accordingly, the plaintiffs are the appellant before this court. This appeal was admitted for finding hearing. White.
3/1/1970.
Judgment dated 3/1.
1996.
3/1/1996. And the following substantial question of law: whether the courts below have erred in holding partition by metes and bounds amongst the parties on the basis of entries in the record of rights, whereas some of the properties stood recorded jointly as well as separately in the name of the parties. Inverted commas. The learned counsel appearing on behalf of the respondents at the threshold has submitted that the substantial question of law so framed is not a substantial question of law, inasmuch as both the courts have appreciated the materials on record and have come to a definite conclusion that there has been partition prior to CS Judicial survey. He submits that whether there was a previous partition or not is essentially a question of fact, and therefore it may be considered that no substantial question of law is involved in this case. However, the parties have advanced their arguments on the merits as well. Okay? The learned counsel appearing on behalf of the appellant has submitted that the common ancestor was one Khudiya Mehto, who died before cadastral survey.
Kudiya Mato was the common ancestor of
Ah.
the party. Right?
Yes. Who died before cadastral survey. And he had two sons, Raghunath Mehto and Baji Mehto. He has submitted that the entire genealogy has been provided in paragraph 2 of the trial court's judgment, and the genealogy is not in dispute, correct?
Yes.
The learned counsel has submitted that the heirs of Raghunath Mehto were the defendants in the suit, and the heirs of Baji Mehto were from the side of the plaintiff. Harihar Mehto, who was the plaintiff number 1, ये कौन सा generation था? Grandson?
Grandson ही है. Grandson.
Just a minute. The learned counsel has also submitted that Raghunath Mehto and Baji Mehto died before the judicial survey operation. Raghunath Mehto died leaving behind his son Jamru Mehto, Balka Mehto, Dheeraj Mehto, while Baji Mehto died leaving behind his sons Ganesh Mehto and Paresh Mehto. Paresh Mehto had also died before the judicial survey, leaving behind his son Binda Mehto and Alice record leaving behind his son Binda Mehto Binda. It was the further case that since the son of Raghunath Mehto was elder and Jamru Mehto was the eldest son of Raghunath Mehto, he was the Karta of the joint family, consisting of Raghunath Mehto and Baji Mehto. It was the further case of the plaintiffs that in course of time, the sons of Raghunath Mehto and Baji Mehto died one after another, leaving behind their sons, plaintiffs and defendants, as their legal heirs and successors. The learned counsel submits that the plaintiffs and the defendants were the grandchildren, grandsons of Raghunath Mehto
and Baiju Mehto.
and Baiju Mehto. He has submitted that the specific case of the plaintiffs was that RS record of right was jointly prepared in respect of the suit property in the name of heirs of Raghunath Mehto and Baji Mehto. Semicolon, some of the land was recorded jointly, while some were recorded separately in the name of sons of Raghunath Mehto. has further submitted that, as per the case of the plaintiff, for the sake of convenience, he has also submitted that after expansion of the family mess and cultivation on some land, the family mess cultivation on some land was being done separately for convenience, but the family land and property were still in joint and they were not partitioned among the family members by meets and bounds. The cause of action arose when the plaintiffs found that the defendants had become dishonest and they were raising unnecessary dispute in the matter of cultivation of joint family property. They had requested the defendants to partition the joint family property by meets and bounds in the month of May 1985, but the defendants at the first instance agreed, but later on avoided their request and consequently the suit was filed. The learned counsel then submits that the defendant number 1, 2, 3 and 5 to 9 appeared and contested the suit, while defendant number 4,
10 and 11.
10 and 11 did not appear. Hence the suit was heard ex parte against them. It was a specific case of the appearing of the aforesaid defendants who filed written statement and contested the suit that there was no valid cause of action, and it was stated that the suit itself was not maintainable. It was also stated that the plaintiffs had not given any particulars of line in the schedule of the property. The specific case of the defendants was that the ancestors of the parties had partitioned the land of partitioned the land long before. ये सब पेड़ लगा रखा है, उल्टा सीधा सब लगा हुआ है।
मेरे पास है।
It was opposed that there was no unity of title and possession amongst the parties, and the ancestors of the parties had partitioned the land of Khata number 2 of village Navadi long before CS survey, and according to that partition, it was so recorded in CS Khata number 8 according to their respective shares. It was further case that even in the RS record, tenants were recorded according to their share with respect to RS Khata number 2. With respect to land of RS Khata number 168 of village Paraidi, it was their case that it was not ancestral property of the parties, rather these were the self-acquired properties of Raghunath Mehto, the ancestor of the defendants, alone by exchange with Abraham Mehto, who was the landlord of the village, in lieu of Raghunath Mehto's own royalty land of Khata number 54 of village Nawadi. It was also their case that Raghunath Mehto exchanged his land of CS Khata number 54 in exchange of land of CS Khata number 273 of Abraham Mehto and heirs of Abhiram Mehto and heirs of Raghunath Mehto, so recorded in RS Khata number 168 of village Parity. While in revision survey, Karan Singh Mehto, son of Abhiram Mehto, was recorded exchange land of CS Khata number 54 in RS Khata number 51. CS Khata number 273 was given which was given in exchange by Abhiram Mehto, was resumed by him after death of the recorded tenant without any issue. Further case of the defendant was that they are dealing with the land of Khata number 2 and they have exchanged plot number 384 with Rameshwar Mehto and others of village Nawadi. It was also denied that Raghunath Mehto was Karta of the joint family and Chamu Mehto was the
Karta of the joint
and Chamu Mehto was the Karta of the joint family, and thus ancestors of the parties had already partitioned their land long before CS survey, and they were holding the land according to that partition. It was asserted that the plaintiffs have no share in the suit land, and thus the plaintiffs had no valid right, title, and interest. The learned counsel for the following issues were framed by the learned court. The issue number 4 and 5 was taken up, and it was held that there was previous partition and both the parties were separate in mess, cultivation and dealings. A previous partition prior to cadastral survey. And concurrent finding was recorded by the first appellate court. The learned counsel for the appellant, while assailing the impugned judgments, has submitted that there was neither there was no proof of previous partition. He has further submitted that even the date of the partition was not mentioned in the written statement of the defendant, nor any such date has been placed on record through oral or documentary evidence by the defendants.
and separate mess and separate partition are not the conclusive.
The
proof of
learned
the
counsel
partition.
has also submitted that merely because the parties are separate in mess and cultivation, the same by itself is not a conclusive proof
Partition.
of partition. He has also submitted that there is a presumption in connection with jointness of Hindu family, and the onus was on the defendants to prove partition through proper evidence. The learned counsel has accordingly submitted that the findings of both the courts with regard to previous partition is not based on cogent evidence, and therefore the substantial question of law is fit to be answered in favor of the applicant. The learned counsel has relied upon judgment passed by Honorable Patna High Court reported in 2000 within bracket 2 bracket close PLJR 522 paragraph 11, and has submitted that the onus was heavy on the defendants to prove previous partition. And has submitted that separation in a partition suit, separation of parties in meson business cannot be treated as a proof of complete partition. The learned counsel has also relied upon the judgment passed by Honorable Patna High Court reported in 1999 1 PLJR 199 equivalent citation, 1998 Supreme within bracket PAT bracket close 597. To submit that, and has referred to paragraph 13 and 14 thereof, to submit that separate in mess and separate cultivation amongst the co-sharers do not mean that there was partition by meets and bound, a separation of one of the co-partners from the ancestral property. He has also submitted that that it has been held that entries in the revenue records cannot prove partition or separation. The learned counsel has submitted that the learned trial court as well as the learned first appellate court has primarily based their findings on the basis of the entries made in revenue records, and therefore the entire approach of both the courts is fallacious, and certainly a substantial question of law arises which has been framed by this court and is fit to be answered in favor of the applicant. That's it. The learned counsel appearing on behalf of the respondents has vehemently opposed the prayer, and apart from the objection with regard to framing of the substantial question of law by submitting that the question so framed is not a substantial question of law, he has also argued the case on merits. The learned counsel has submitted that the findings recorded by the courts is that the partition had taken place prior to CS survey, and CS survey had taken place around 90 years back. 90 years कब हुआ था CS survey?
1905
CS survey had taken place way back in the year 1905. He submits that therefore there was no question of any person being examined who was alive way back in the year 1905. He has submitted that this aspect of the matter has been taken note of by the learned courts, and the learned courts have thereafter dealt with the various entries in the revenue records and also considered the various oral evidences placed on record to come to a finding that the parties were that there was a previous partition prior to CS survey. The learned counsel submits that with the passage of time, specific date of partition was not placed on record, but there was sufficient material placed on record to show that there was previous partition prior to the CS survey. The learned counsel has submitted that the learned trial court has taken into consideration that the presumption of jointness, the learned counsel has also submitted that it was an admitted fact on record that the parties were separate in mess, cultivation, and also dealing with the property. The council submits that each and every entry made in the record of rights and it has been taken care of by both the courts along with the oral evidences on record to come to a finding that there was previous partition between the two brothers, namely Raghunath Mehto and Baji Mehto, prior to CS record, prior to registered survey. He submits that the substantial question of law, otherwise also, is fit to be answered in favor of the respondents when seen in the light of the facts and circumstances of this case. The learned counsel has also submitted that the judgment cited by the appellant does not apply to the facts and circumstances of this case. इतना खाली लिखेंगे, बाकी का हमको डील करना है, ठीक है? आज 10 तारीख है ना? Arguments concluded. Order is reserved. Post for judgment on 12th.
Passover case item 6, second bill 189 of 2003.
Who is appearing in this Passover case? Court कितने बजे खुलता है? आइए जरा दिखाइए. Where is Mr. Sangha? So ना हम लोग 4 बार कॉल करेंगे, उसके बाद आराम से 1 लाख रुपए कॉस्ट कराएंगे, ठीक है? पहला फर्स्ट आवर में कॉल किए नहीं, 11:30 बजे हम लोग पोस्ट किए, we were in the midst of the proceedings, nobody is there. 2:15 बजे फिर से कॉल करेंगे, kindly let him know. This case will be adjourned with the cost, heavy cost. ऐसे नहीं होगा DT करके हमको कोई शौक नहीं, कॉस्ट से करेंगे, अपने पेमेंट करेंगे कॉस्ट का, क्योंकि जब रेस्टोर होगा ना तो भी कॉस्ट का पेमेंट करना पड़ेगा, बिना कॉस्ट पेमेंट के रेस्टोर भी नहीं होगा। DT करने से क्या फायदा?
कोई फायदा नहीं,
कोई फायदा नहीं, कॉस्ट के साथ करेंगे जॉइन तो ज़्यादा ठीक है। चलिए बुलाइए, नेक्स्ट केस कॉल करें, 2:15 को फिर से कॉल करेंगे, खाली याद रखिएगा कब कब कॉल करना है। कौन है? कोई बात नहीं, आप आइए 2:15 में, आपको कॉस्ट चाहिए ना, तैयार हो। कॉस्ट हम लोग इस बार लीगल एड वगैरह को नहीं देते हैं, सिविल लिटिगेशन में कॉस्ट पार्टी को जाएगा, ठीक है? आप सोचिए ज़्यादा से ज़्यादा कॉस्ट कैसे लग सकता है।
Item 10, second April 75 of 2003.
सोमवार को रख दीजिए।
क्या हो गया?
इसमें हम एडिशनल सब्सटेंशियल क्वेश्चन ऑफ लॉ के लिए दिए हैं, और बहुत रिलेवेंट, एक बार देख
देखिए
लीजिए।
एक बात बता रहे हैं
जी,
ये सब्सटेंशियल क्वेश्चन ऑफ लॉ जिन्होंने बनाया है ना, बहुत सोच समझ कर, इसमें कोई स्कोप नहीं है।
नहीं है स्कोप,
क्या स्कोप?
स्कोप है,
और कोई लिबर्टी भी नहीं दिया।
नहीं वो अलग चीज़ है, वो तो लॉर्डशिप का प्रिविलेज है कि इसको फ्रेम करें या नहीं करें, वो चीज़। इसमें एक बार देख लीजिए सप्लीमेंट्री एफिडेविट लॉर्डशिप में,
क्या सप्लीमेंट्री है?
जो एडिशनल सब्सटेंस फ्रेम किए हैं, सप्लीमेंट्री एफिडेविट
आप फाइल किए
फाइल
हैं?
की लॉर्डशिप।
कहाँ? सप्लीमेंट्री आपके?
जी, whether the first appellate court committed perversity in reversing the judgment and decree passed by the learned trial court by not considering that suit is bad for non-joinder of necessary party laws.
Who were the necessary?
I'm coming here.
इसलिए स्पेसिफाई भी नहीं किया who was the necessary party.
इसमें शो करते रहे हमारा रिटन स्टेटमेंट से लॉस, रिटन स्टेटमेंट
नहीं, आप इशू दिखाइए ना, फाइंडिंग दिखाइए।
हाँ, इशू दिखा दो।
आप रिटन स्टेटमेंट में लिखे हैं और उसका कोई इशू नहीं बना है,
नहीं,
कैसे
इशू
पता
बना
चले?
है, बना है लॉर्ड।
Where is that?
पैरा 6 लॉर्ड सी, सॉरी, पैरा 4 लॉर्ड सी, इशू पेमेंट लर्निंग ट्रायल कोर्ट लॉर्ड। Lord, page 10 of the learned trial court judgment, Lord. Is the suit bad for non-joinder of necessary party, Lord? And now, Lord, may kindly.
Just a moment. Title suit. Right?
Yes.
This is the suit back for
Non-joinder of necessary party.
okay, issue number 5.
5.
Correct?
Ji.
How
No,
has
Lord.
it been dealt with?
Yes. Findings, Lord, may kindly see.
ये कौन था नेसेसरी पार्टी?
Necessary party है बताया। Para 5 of the my written statement, Lord, see that suit is bad for non-joinder of necessary party. All the heirs and descendants of Murlidhar Singh and Chakradhari Singh are necessary party in the present suit, and in their absence, the suit cannot be proceed.
कौन-कौन है? कौन-कौन छूट गया?
मुरलीधर सिंह एंड चक्रधारी सिंह, हम जिनोलॉजी थोड़ा बता सकते हैं।
जिनोलॉजी कहाँ से पता है?
नहीं, हम जजमेंट में ही दिया हुआ
तो ये दोनों के when you say that it is bad for non-joinder of necessary parties,
लॉर्ड।
by stating that all of them were required to be made parties.
The
So
plaintiff,
who were the persons who were left?
I am coming, Lordship.
You have to specify in the written statement itself.
It has been mentioned.
बताइए.
Murlidhar Singh and Chakradhari Singh are the necessary party in the present suit, and their absence the suit cannot be proceeded. The Murlidhar Singh and Chakradhari Singh were not made party, Lordship.
Who are they?
They are the. I am coming, Lordship. The land was recorded in the name of Gopal Singh, Lordship. And Gopal Singh died, leaving behind two sons, Guman Singh and Trishul Singh. And Guman Singh died, leaving behind his widow Churamani Devya, and she was no issue. And Trishul Singh, Lordship, died, leaving behind two sons, Murlidhar Singh and Chakradhari Singh, Lordship. And plaintiff
Murlidhar and
Chakradhari Singh. And plaintiff himself admitted that there was no previous partition, Lordship. Lordship, may kindly see.
You see, Guman also died.
Yes.
Churamani also died.
Yes.
Issueless. So there was no need for any kind of assignment to this branch of Guman.
Necessary, Lordship. Because
How is it necessary?
Lordship, because the plaintiff, Lordship, may kindly see judgment passed by the trial court.
नहीं आपको पता है genealogy पता है.
जी.
Then the entire property of Gopal Singh would devolve upon Trishul Singh.
Yes.
So what is the idea of
Yes.
there was no
I am
partition
coming,
or
Lordship.
partition?
The Trishul Singh died, leaving behind the Murlidhar Singh and Chakradhari Singh, and Murlidhar Singh died, leaving behind his only son Bhutnath Singh, and Bhutnath Singh died, leaving behind his widow Sarla Devi, Lordship.
So
But because there is no partition, Lordship, the plaintiff himself stated in cross examination that
there is a partition suit.
No, it is a title suit, Lordship. Title
suit.
suit was filed by the plaintiff for cancellation of my sale deed, Lordship.
Whose sale deed?
My sale deed.
In whose neighbor? The sale deed was executed by whom and in whose neighbor?
The sale deed was executed by the in the year 1995, Lordship.
By whom? By whom and to whom?
By the defendant number 1 and defendant number 2. Defendant number 1 and defendant Sarla Devia and Jhamku Singh.
Sarla Devi and
Jhamku Singh.
who is Jhamku Singh?
They are the descendants of the Gopal Singh, Lordship.
अरे भाई सब तो कॉमन एंसेस्टर है ना ये
गोपाल
जम्मू सिंह किनका बेटा है
सन ऑफ चक्रधारी
चक्रधारी
सन ऑफ चक्रधारी सन ऑफ चक्रधारी
राइट
यस
ये जो सरला देवी है मुरलीधर का बेटा है भूतनाथ मुरलीधर मर गए when did he die
यस
Date of death has not been mentioned, Lordship.
not mentioned right उनका बेटा है भूतनाथ
जी.
भूतनाथ का भी डेथ हो गया बच्ची सरला देवी who is the executant of the deed
Yes.
she is the plaintiff herself right उसके बाद त्रिशूल सिंह के दूसरे बेटे हैं चक्रधारी
जी.
उनका बेटा है झमकू सिंह he is the co-plaintiff he is the co-executor of the deed
Yes.
तो फिर कैसे पार्टी नहीं है कौन छूट गया who is the necessary party who has been left out आप बोल रहे मुरलीधर और चक्रधारी को पार्टी नहीं बनाया जो मर गए उनको क्या पार्टी बनाई
हम लिखे हैं पर all the heirs and descendants of the Murlidhar Singh and Chakradhari Singh are the necessary.
आप तो बता ही रहे ना कौन heirs and successors
इसको थोड़ा सा हम देख
नहीं कुछ देखना नहीं है इसमें
इसको सो
नहीं कुछ हम ये नहीं
एडिशनल छोड़ देते हैं
एडिशनल रिजेक्ट कर देते हैं पहले रिजेक्ट कर देते हैं दैट हैज टू बी
इसको आज एडिशनली थोड़ा सा हम देख लेते हैं थोड़ा सा बढ़िया से नहीं पढ़ पाए तो बढ़िया से पढ़ नहीं पाए
जबरदस्ती आपको बोल रहे हैं ना
नहीं थोड़ा सा एक
क्वेश्चन ऑफ लॉ बहुत सोच के बना है नहीं
इसको आज
यू डोंट प्रेस इट
अच्छा आई एम नॉट प्रेस
देखिए एसए नंबर 75 of 2003 the learned counsel for the appealant has submitted that he does not want to want to press the additional substantial question of law as proposed. Wide. उसको कोई affidavit में भी नहीं फाइल किया, ऐसे फाइल किया. As proposed by filing it on a sheet of paper on 1/8/2025. आप थोड़ा सा देखते हैं क्या?
नहीं इसको
देखते हैं ना?
नहीं इसमें थोड़ा सा तबीयत भी ठीक नहीं लग रहा, हम पढ़ के भी नहीं आए इसको बढ़िया से इसीलिए.
अरे भाई हम भी नहीं पढ़ के आए.
नहीं
थोड़ा सा देखते हैं क्या क्वेश्चन ऑफ लॉ है. आपको पूरा तबीयत मत खराब क्या करिए.
नहीं मेरा तो सही तबीयत ठीक नहीं है.
तो आप पढ़िए थोड़ा. आप
हम पढ़ देते हैं मैं आज इसको फाइनल नहीं किया जाए किसी दूसरे.
हम फाइनल नहीं करेंगे.
हाँ हम पढ़ देते हैं. हम
क्योंकि ऐसे नहीं इतना सब्सटेंशियल क्वेश्चन ऑफ लॉ 3 बना है.
ऑर्डर नंबर 4 लॉर्ड.
थोड़ा देखें तो सही क्या है.
Whether even on the findings the lower appellate court that one of the executors of the sale deed in favor of the plaintiff died on 16/10/1975. The finding that sale deed executed on 23/10/1995 executed by one Srimati Chudamani Devi is not vitiated by clear error of law amounting to substantial portion of law.
इसका क्या मतलब हुआ?
The Chudamani Devi died 16/10/1975 and sale deed executed on 23/10/1995. The sale deed was executed by the dead person. After was executed by the dead person. Lord.
Sale deed में date and registration में फर्क है क्या?
हाँ अलग है.
When was it registered?
The sale deed executed on 23/10/1995. That time Lordship, the Chudamani Devi was not alive Lordship.
और आगे क्या है next?
When a sale deed executed a person along with other, one of them found to be dead on the date of alleged execution of the sale deed cannot be treated as invalid as also had to convey nothing to the assignee thereunder. Whether on the fact and circumstances of the case, the lower appellate court justified granting the plaintiff in decree for recovery of purchase. Sale deed executes.
So just a moment. The suit was filed for
cancellation of my sale deed.
Cancellation of your sale deed. There were 2 persons who had executed the sale deed. Correct. One of them she died prior to
execution of the sale deed.
But still, the trial court had decreed the suit.
Dismissed the suit.
The trial court had dismissed the suit.
Not.
Okay. Appellate court.
Appellate court allowed the suit that I admitted that the exhibit C Lordship died on 16/10/1975 and sale deed executed on 23/10/1975 Lordship.
The appellate court did what?
No, I am coming Lordship.
The suit is dismissed on contest.
Yes.
Yes. The challenge to the sale deed was declined.
Yes.
The challenge to the sale deed was
declined by the Lebanon trial court Lordship.
So now the question is whether the sale deed executed by a dead person, one of them,
is considered to be
can be said to be a valid or it's a nullity.
Yes. Yes.
तो अब इसमें आप कितना टाइम चाहिए?
नहीं इसको देख लेते हैं थोड़ा सा. आज हम बढ़िया से नहीं देखे इसीलिए फुल कॉन्फिडेंस है.
आज आपकी किस्मत में नहीं है ऑर्डर. अगला डेट का किस्मत हम नहीं डिसाइड करेंगे.
नहीं अगला डेट को कभी इसको बढ़िया से देखेंगे. अदरवाइज हम
कल
नहीं कल भी कुछ मैटर लगा हुआ है हमारा इसीलिए बोल रहे. सोमवार को हम बोल रहे हैं, ज्यादा दिन नहीं बोल रहे हैं.
वीकेंड के बाद तो हम बहुत चीज
नहीं सोमवार को रख दिए थे क्योंकि फ्राइडे को भी 2 मैटर लॉर्डशिप किए हैं.
आपको लग रहा है इतना केस हम कर लेंगे?
नहीं आप तो हुजूर कर लीजिए. इसको सोमवार को रख दिया फिर जो ऑर्डर होगा हम बढ़िया से पढ़ेंगे.
ठीक है सुनिए.
वेडनेसडे कर लीजिए लॉर्डशिप.
खास मुहूर्त निकाले हैं.
नहीं वेडनेसडे को मंडे को हम रहेंगे नहीं लॉर्डशिप.
वेडनेसडे को कोई मैटर रखे हैं ना हम लोग? नहीं रखे ना. थोड़ा सा लिखाते हैं.
छोड़ दिया था.
थोड़ा सा खाली लिखाते हैं बैकग्राउंड जिससे मेरे मेमोरी में रहे कि हम क्या सुने.
ठीक.
फर्दर This appeal has been filed against the judgment dated 20/12/2002, within bracket, decree signed on 10/1/2003, bracket close, passed by learned Additional District Judge Roman 11 Dhanbad, entitled Appeal number 42 of 2001. अब इसमें कॉस्ट आइटम में क्यों लिखे पार्टली अलाउड?
Most item.
और यहाँ पे पेज नंबर 3 में लग तो नहीं रहा है कि पार्टली अलाउड
नहीं ये सर पार्टली
है?
हाँ
क्या चीज पार्टली अलाउड?
वो अपील में वो पार्टली अलाउड
Which part has been allowed? Okay, just a moment. And the appeal has been partly allowed.
Around 15.
Yes. The trial court judgment was passed by learned Munsif Roman to Dhanbad in title suit number 104 of 1997. In judgment dated 9/8/2001, within bracket, decree signed on 21/8/2001. The suit was filed seeking a declaration that the registered sale deed number 1676 dated 18/3/1996 and 5065 dated 10/8/1996 were null and void, collusive, manufactured, and were without consideration, and also for declaration of right, title, and interest of the plaintiff with respect to Schedule C, D, and B properties. A relief was also prayed that if the plaintiff is found dispossessed from the suit property, the relief of recovery of possession be granted and a permanent injunction be issued against the defendant. The case of the plaintiff was that the land in Mausa number 320, Khata number 22, including plot number 140, was originally recorded in the name of Gopal Singh, who died leaving behind his two sons, Guman Singh and Trishul Singh. Guman Singh died leaving behind his widow Churamani Devi, having no issue. Trishul Singh also died leaving behind his two sons, Murlidhar Singh and Chakradhari Singh. Murlidhar Singh died leaving behind his only son, Bhutani Singh, and Bhutani Singh died leaving behind his widow, Sarla Divya. Chakradhari Singh died leaving behind his two sons, Gauri Singh and Jyoti Singh, and Jampu Singh. It was the case of the plaintiff that after death of recorded heir Gopal Singh, the two sons inherited the properties and there was an amicable partition with respect to the entire land of Khata number 22, including plot number 140, area 82 decimal. After death of Gopal Singh, after that of Guman Singh, his widow Churamani Divya, Jyoti Singh and Gauri Singh, son of late Chakradhari Singh, disposed of their share in plot number 140 in favor of the plaintiff, measuring an area of 51,3 by 4 decimal by virtue of registered sale deed number 9657 dated 8/11/1975. Husband of defendant number 1, Sarla Devi, Bhutani Singh, had sold 23 decimal in plot number 140 to Jitu Mehto and Nitai Mehto, the pro forma defendant number 4 and 5 by registered sale deed number 18614 dated 25/6/74. Similarly, the father of defendant number 2, Churamani Singh, sold 7 decimal of plot number 140 along with other lands in favor of the pro forma defendant number 4 and 5 by registered sale deed number 10037 dated 11/1/1972. In this way, the entire land, that is 82 decimal of plot number 140, was sold. And after purchase of 51/3 by 4 decimal of land, which was mentioned in the Schedule B property, the plaintiff started using the land as Kalyan. The cause of action arose when in the year 1996, defendant number 3 tried to disturb the peaceful possession of the appellant with respect to Schedule B property. And in the show cause, the plaintiff found that the respondent number 1, Sarla Devi, had executed registered sale deed number 1676 dated 18/3/1996 in favor of the respondent number 3 in favor of Srimati Poda Devi in plot number
He is the appellant before this one.
140, measuring 1/4 decimal of land. And respondent number 4 con, and the court defendant had entered into agreement with respect of 10.5 decimal in favor of Sarla Devi in plot number 140, and Jamku Singh had executed a registered sale deed in favor of Poda Devi by virtue of registered sale deed number 5065 dated 9/8/1996, measuring 10 decimal in plot number 140. It was asserted that the defendant number 1 and 2, intentionally knowing fully well that these lands, Schedule C and Schedule D, were a part of Schedule B property of the plaintiff, have already been sold by Churamani Divya, wife of Guman Singh, and Jyoti Singh, son of Chakradhari Singh, to the appellant, and hence the sale deeds were alleged to be forged and fraudulent. The written statement was filed by the defendants who had opposed the prayer and ultimately the learned trial court dismissed the suit. the learned first appellate court. The plaintiff was the appellant and the learned first appellate court has set aside the judgment and decree of the trial court and held that the deed number 9675 dated 23/10/75 in favor of the plaintiff was valid and genuine document, and hence all the subsequent deeds with respect to land mentioned in deed number 9657 dated 23/10/1975 were declared null and void. Thus, the second appeal was filed by the defendant number
Defendant number 3.
Defendant number 3, Pata Devi, on the following substantial questions of law. ठीक है, dated 24/12/2003 में, correct?
जी.
The learned counsel for the appellant has commenced the hearing of this case and he submits that the matter be posted for further hearing on Monday.
Yes, Monday.
No, Wednesday.
On Wednesday. With the consent of the counsel for the parties, post this case for further hearing on next Wednesday to be taken up as first case at 10.
Okay.
इसको जो है ना इसके लगा दूँगी। इसका जितना टेक्नोलॉजी लिखे हैं ट्रायल कोर्ट में पैरा 2 में पूरा स्टोरी।
Item 11, second appeal 190 of 2003 alone technical.
Yes, who is the appellant? Who is the appellant?
Yeah, Vishwajit is appearing for the appellate court.
He was here just now.
Yes.
I saw him here. It is the agreement of sale.
But agreement of sale is,
Exhibit,
yes, but exhibit 4.
let us see. Exhibit 4 दीजिए. Agreement of sale में ही लिखा होना चाहिए ना whether he will pay rent or not pay rent. Normally रहता है.
But so far as agreement to sale is concerned, but we have stated that it is forged and fabricated.
So that is not the substantial question.
No, that is not, but not, that is the finding of the court. That it is forged and fabricated.
Let us see.
Yes.
If that is the finding of the court, matter ends.
Yes.
Where is that finding? Trial court का finding है.
Oh, reversal है.
Okay. Let us see the finding of the learned
Yes.
first appeal. ये दोनों ने अपील क्यों फाइल किया?
But दो अपील हुआ है लॉर्ड। एक है सूट फॉर स्पेसिफिक परफॉर्मेंस जो वो प्लेंटिफ है और एक है इविक्शन सूट जिसमें हम प्लेंटिफ। सूट फॉर स्पेसिफिक परफॉर्मेंस क्योंकि डिक्री हो गया तो मेरा इविक्शन सूट डिसमिस हो गया।
जब एग्रीमेंट वाज forged and fabricated, तो डिक्री कैसे हो?
बट ट्रायल कोर्ट उनका सूट डिक्री कर दिया इनिशियली एग्रीमेंट वाला, तो मेरा सूट इविक्शन का डिसमिस हो गया और उसके बाद हम अपील फाइल किए, मेरा जो है इविक्शन उनका एग्रीमेंट फॉर फैब्रिकेटेड हो गया तो उसके बेसिस पे
तो उनके केस में
eviction
क्या सब्सटैंशियल क्वेश्चन ऑफ लॉ है?
सॉरी
ये दूसरा 178 में क्या?
178 will not arises out of this is arises out of specific performance.
तो इसमें कोई सब्सटैंशियल क्वेश्चन ऑफ लॉ
इसमें क्वेश्चन ऑफ लॉ नोट 18/7/2006 Yes. Whether in case of the appellant possession as prospective purchaser by virtue of agreement of sale, the defendant can be said to be a tenant under the plaintiff. Whether the nature of possession of the appellant having changed as prospective purchaser in part performance of contract or sale, the relationship
नहीं
of
ये नहीं,
sorry,
ऐसे 178
178. Whether the learned lower appellate court have erred in holding that the time was essence of contract, ignoring the clause which clearly provides that if the first party refuses to execute the sale deed within time frame fixed, then in that case the second party can move the court for appropriate relief and get the deed executed. Whether the lower appellate court erred in reversing the judgment and decree of the trial.
इसका क्या मतलब?
But first one would what I understand that after
ये
the
बाद का इसका क्या मतलब है?
बात खत्म हो चुकी है formal
फॉर्मल क्या है?
क्योंकि whether lower
It's
appellate
absolutely open. It opens up everything. Whether the learned lower appellate court erred in reversing the judgment and decree of the learned trial court in wrong perspective. It's absolutely vague.
yes
ये कैसे सब्सटैंशियल क्वेश्चन ऑफ लॉ हम लोग आंसर करेंगे? बताइए. Yes, Mr. Kumar. Yes. Which case do you want to argue first?
Second appeal 178.
178. You read the substantial question of law and explain the second one.
The second appeal was admitted on 18/7/2006 on the substantial question of law that was read whether the lower appellate court has erred in holding that the time was essence of contract, ignoring the clause which clearly provides that if the first party refuses to execute sale deed within the time fixed, then in that case, the second party can move the court for appropriate relief and get the sale deed executed.
आगे बढ़िए. यहाँ तक तो ठीक है. आगे.
And whether the learned lower appellate court erred in reversing the judgment and decree of trial court in wrong perspective.
इसका क्या मतलब? Explain. Is it a substantial question of law?
It has been framed.
Yes, it has been framed. Now I am looking at it. Are you opposing this substantial question of law? Second part.
yes
He has got a right to oppose. बताइए हम क्या चीज ओपन करेंगे इसमें? सब चीज. Everything.
It is judgment of reversal because
Yes, so what? Merely because it's a judgment of reversal, is it necessary that a substantial question of law will arise? No. Then I'll have to hold that the appellate court has no jurisdiction to reverse the judgment. Okay.
no, appellate court has
The
every
wrong
jurisdiction to appellate
Just
court
a
has
moment. Please hold on.
So-
Wrong perspective से क्या मतलब? Explain this wrong perspective to the court. Okay? What is wrong perspective? In the records, what is that wrong perspective?
What happened in this case, the lower appellate court has came to a third finding, third case. Therefore, this substantial question of law is there.
Now you place your case. We have seen the substantial question of law.
Okay.
You place your case.
The case is like this. Original plaintiff was Govardhan Thakur. He brought this suit, title suit 56/84 for a decree for a specific performance of contract on the basis of an agreement dated 6/10/1983, that is Exhibit 4. The
Dated
plaintiffs
6/10/1983, Exhibit 4.
it is the case of the plaintiff that Praful Chandra Mitra was owner of the suit land and plaintiff was a tenant under it since 1953, where he used to run his hair cutting salon. After death of Praful Chandra Mitra, defendant number 1 and 2 became the owner. Defendant number 1 and 2, being owner of the suit property, approached the plaintiff for sale of the suit property, and accordingly on 6/10/1983, these defendants entered into an agreement for sale with the plaintiff on a consideration money of rupees 30,000. As such agreement was executed by defendant number 1 and 2 on 6/10/1983 and received sum of rupees 5,000 as an advance and put the plaintiff in possession in part performance of agreement. The sale deed was to be executed within 6 months from 6/10/1983. After execution of agreement, the plaintiff came in possession of the property as owner and is no longer a tenant. Tenant of defendant 1. The plaintiff was ready and performed his part of contract, but the defendant 1 and 2 lingered the same for some pretext or other. Plaintiff on 11/4/1984 sent a notice, that is Exhibit 1, requesting them to execute sale deed, upon which on 25/4/84 they informed the plaintiff through letter that they had already sold the suit property to the defendant number 3 and 4 on 6/4/84. Therefore, the cause of action for this suit. Defendant appeared, filed their contesting written statement denying the execution of agreement, and then also they said that even if it is executed, it is not binding upon them. And on the basis of this pleading of party, issues were framed by the trial. The issue is like this: whether the suit is maintainable in its present form, is there any cause of action for the suit, is the suit barred by law of limitation, is the suit barred by res judicata, is the suit barred by waiver, acquiescence and estoppel.
जजमेंट तो हिंदी में है, इंग्लिश में किया है क्या?
नहीं, हिंदी.
ट्रायल कोर्ट हिंदी में पूरा अपलोड कर देंगे.
Whether the plaintiff is entitled for a decree.
So considering that substantial question of law, which are the issues you are concerned with?
Issue number 6. Each suit is the plaintiff entitled for a decree on basis of agreement at 6/10/83. एक बार ट्रायल कोर्ट का जजमेंट पढ़ देते हैं. Since it is judgment of reversal, वर्तमान वाद के
पूरा
अनुसार
जजमेंट नहीं पढ़ना है, आप इसका 6 का फाइंडिंग देखिए. कहाँ से 6 का शुरू हो रहा है? 6 पैरा 6 से
जी, पेज 8. पक्षकारों के वाद के तथ्यों और वर्तमान वाद की संपूर्ण परिस्थितियों के आलोक में वर्तमान वाद बिंदु सबसे महत्वपूर्ण है. अतः इस पर सर्वप्रथम विचार करना आवश्यक है, क्योंकि इस वाद बिंदु के संबंध में उभय पक्षों द्वारा मौलिक एवं कागजी साक्ष्य अपने अपने वाद के तथ्यों के संबंध में दिए गए हैं, जिसका वर्णन संक्षेप में करना आवश्यक है. इस संबंध में वादी के तरफ से कुल 10 साक्ष्यों का न्यायालय में परीक्षण कराया गया है, जिनमें साक्षी संख्या 1 रामेश्वर साहू औपचारिक प्रकृति साक्षी हैं, जिनके प्रमाणित करने पर नोटिस दिनांक 11/4/84 उससे संबंधित पत्रालय रसीद वादी के तरफ से एवं प्रतिवादी के तरफ से प्राप्ति स्वीकृति रसीद तथा उक्त नोटिस से संबंधित जवाब को वर्तमान वाद में क्रमशः प्रदर्श ए एवं तथा ए एवं बी अंकित किया गया है। इस साक्षी के वर्तमान वाद के तथ्यों के संबंध में कोई जानकारी नहीं है, अतः उक्त प्रदर्शों के बारे में आगे वर्णन किया जाएगा। वादी की तरफ से परीक्षित अन्य साक्षी तथ्य के साक्ष्य जिनमें साक्षी संख्या 5 गोवर्धन ठाकुर वर्तमान वाद के वादी हैं तथा अपने वाद पत्र के तथ्यों का समर्थन करते हुए कथन किए हैं कि विवादी दुकान प्रतिवादी
सर इतना जजमेंट जैसे नहीं पढ़ सकते ना,
एक-
आप
एक-
अपने लिए पढ़ रहे हैं, हमको तो कुछ समझ नहीं आ रहा आप क्या पढ़ रहे हैं। भाई यू हैव टू एक्सप्लेन, यू आर रीडिंग इट, यू कम टू द फाइंडिंग ऑफ द लर्नेड ट्रायल कोर्ट, what finding has been recorded. You can't make the entire judgment like this. We are in substantial question of law. The findings which are otherwise recorded are finding, isn't it?
After discussing the evidence, the court has come to a finding
Para number?
at para 12, page 27.
Para 12 page 25 में है। देखिए आपको बताते कौन कौन सा पैरा आप पढ़ लीजिए। आप पैरा 10 पढ़ लीजिए, नहीं पैरा 11 पढ़ लीजिए, राइट। पैरा 11 एविडेंस का रिकॉर्डिंग होने के बाद पैरा 11 से पढ़िए।
प्रतिवादी के विद्वान अधिवक्ता की दलील थी कि अभिलेख पर आए अन्य साक्ष्यों के साथ साथ विशेषज्ञ साक्षी केदारनाथ प्रसाद एवं उनके प्रतिवेदन पर दर्ज एच के आलोक में कथित इकरारनामा दिनांक 6/10/83 जाली एवं बनावटी है, जिसके आधार पर वर्तमान वाद लाया गया है। अतः वर्तमान वाद को असफल घोषित किया जाना चाहिए, मगर वादी के विद्वान अधिवक्ता इस दलील का विरोध किए एवं अपने अन्य मौखिक एवं कागजाती साक्ष्यों के साथ साथ साक्षी संख्या 7 चंद्रशेखर जौहरीहार उनका प्रतिवेदन पर दर्ज 7 तथा प्रतिवादी साक्षी संख्या 10 केदारनाथ प्रसाद के कथनों के संबंध में इकरारनामा दिनांक 6/10/83 वैध एवं विधि सम्मत होने के साथ साथ प्रतिवादियों पर बाध्यकारी होने का दावा किए, क्योंकि प्रतिवादी ट्रेस फोर्जरी के आधार पर प्रदर्शनकार को जाली करार देने के पक्ष में हैं, जबकि स्वयं उनके विशेषज्ञ साक्षी के अनुसार भी ट्रेस फोर्जरी के संबंधित लिखावट पर पाए जाने वाली विशेषताएं मुख्यतः संबंधित हस्ताक्षर पर न गड्ढे हैं और न स्याही फुटा हुआ है और न पेंसिल से ट्रेस की कोई संकेत है। अतः ऐसी स्थिति में प्रतिवादी का इकरारनामा दिनांक 6/10/1983 के प्रभाव से बचने का प्रयास को असफल घोषित किया जाना चाहिए। It is their evidence on behalf of the defendant. His witness have stated that it is not a traced signature.
ट्रेस्ड सिग्नेचर होने से ही फोर्जरी होता है क्या?
नहीं, और भी तरह से प्रूफ तो इनको करना होगा ना। I have brought the document on record.
Yes.
अतः ऐसी स्थिति में प्रतिवादी का इकरारनामा 6/10 के प्रभाव से बचने के प्रयास को असफल घोषित किया जाना चाहिए। इसके साथ ही उनकी अगली दलील थी कि प्रदर्शनकार के हस्ताक्षरों को प्रतिवादी संख्या 2 के द्वारा स्पष्ट रूप से इनकार नहीं किया गया, बल्कि उनके द्वारा स्वीकार किया गया है कि ऐसे ही हस्ताक्षर से ए तथा उनका पुत्र बराबर किया करते हैं। यह भी कि प्रदर्शनकार से संबंधित स्टाम्प पेपर स्वयं प्रतिवादी दीपक कुमार मित्रा द्वारा क्रय किया गया है। अतः वादी साक्षी संख्या 3 ज्ञानचंद मेहता एक स्वतंत्र साक्षी हैं और उनके विरुद्ध अभिलेख पर ऐसा कुछ नहीं आया जिसके आधार पर उनके कथनों को अस्वीकारा जा सके, और वे साक्षी प्रदर्शनकार की विश्वसनीयता को स्वीकार करते हुए स्पष्ट कथन किए हैं कि प्रदर्शनकार प्रतिवादी दीपक मित्रा एवं वादी गोवर्धन ठाकुर के निर्देश पर ओट अंकित किए थे और उस टंकन के विरुद्ध प्रतिवादी के तरफ से मात्र इतना ही कहा गया कि प्रदर्शनकार पर टंकक के हस्ताक्षर नहीं है और कहीं कहीं कंडिका बदलने में डबल स्पेस नहीं छोड़ा गया है। अतः ऐसे स्वतंत्र साक्षी के कथनों को बिना किसी आधार के अस्वीकार नहीं किया जा सकता है और वह भी उस साक्षी के कथनों को वादी के तरफ से परीक्षित सभी साक्षी एक स्वर में समर्थन किए हैं। वर्तमान दलील के संबंध में उभय पक्षों को सुनने तथा अभिलेख पर आए उक्त वर्णित साक्ष्यों के अवलोकन से स्पष्ट है कि वादी के तरफ से प्रस्तुत की गई उक्त दलीलों में काफी बल है, क्योंकि वादी तथा प्रतिवादियों के तरफ से परीक्षित अन्य साक्ष्यों को अलग भी कर दिया जाए तब भी वादी के तरफ से परीक्षित साक्षी संख्या 3 ज्ञानचंद मेहता एवं चंद्रशेखर गौरिहार के साथ साथ प्रतिवादी के तरफ से परीक्षित साक्षी ईरा मित्रा एवं केदारनाथ प्रसाद के कथन एवं उनके प्रतिवेदन से वर्तमान वाद के तथ्यों एवं संपूर्ण परिस्थितियों के आलोक में देखा जाए तो भी विवादास्पद इकरारनामा 6/10/1983 के स्टाम्प पेपर क्रय कर प्रतिवादी संख्या 1 के निर्देश में टंकित होना तथा वादी के तरफ से परीक्षित साक्षी सुखनंदन शर्मा तथा बंसी ठाकुर के समक्ष प्रतिवादी संख्या 1 एवं 2 के हस्ताक्षर होना, विवादास्पद मकान को 30,000 रुपये में विक्रय होना और अग्रिम रूप में 5,000 रुपया प्राप्त करने के संबंधित विश्वसनीयता को अस्वीकार करना न्यायसंगत नहीं होगा, क्योंकि प्रदर्श 4 पर के प्रतिवादी संख्या 1 एवं 2 के हस्ताक्षर के जाली होने का एकमात्र आधार ट्रेस फोर्जरी कहा गया है और प्रतिवादियों की तरफ से परीक्षित विशेषज्ञ केदारनाथ प्रसाद के कथनों के अनुसार प्रदर्श 4 के प्रतिवादी संख्या 1 एवं 2 के हस्ताक्षर में ट्रेस फोर्जरी का कोई लक्षण नहीं पाए। साथ ही प्रदर्श 4 पर के प्रतिवादी संख्या 1 एवं 2 द्वारा किए गए हस्ताक्षर को स्वीकार किए गए प्रदर्श ई पर उन दोनों के हस्ताक्षरों को नंगी आंखों द्वारा तुलनात्मक ढंग से देखा जाए तो कोई अंतर नहीं है और न ही उसकी सत्यता को प्रभावशाली ढंग से अस्वीकारने की हिम्मत प्रतिवादी साक्षी केदारनाथ प्रसाद एवं ईरा मित्रा कर सकी हैं। इसके साथ ही पक्षकारों की तरफ से नोटिस के आदान प्रदान तथा जिस तरह का साक्ष्य एवं तथ्य अभिलेख पर लाया गया है उससे स्पष्ट है कि दिनांक 6/10/1983 को निष्पादित संविदा विधि सम्मत एवं प्रतिवादियों पर बाध्यकारी है, क्योंकि यह संविदा प्रदर्श ई तथा उसके संबंधित इकरारनामा के अस्तित्व में आने के पूर्व का है। अतः इस संबंध में प्रतिवादियों की तरफ से दाखिल उक्त वर्णित प्रदर्शों का बहुत अधिक महत्व नहीं है, जबकि दूसरी तरफ वादी के तरफ से दाखिल प्रदर्श 4 विशेषज्ञ का प्रतिवेदन दिनांक 29/2/88 प्रदर्श 7 के साथ साथ अन्य कागजात जिसका वर्णन ऊपर किया गया है बहुत ही महत्व रखता है। अतः प्रतिवादी संख्या 3 एवं 4 के नाम से में विवादास्पद मकान का दाखिल खारिज होना एवं उनके द्वारा कर के भुगतान का बहुत अधिक महत्व नहीं रह जाता। साथ ही ऐसी जालसाजी को बहुत ही अकाट्य साक्ष्यों के द्वारा साबित करने का दायित्व प्रतिवादियों पर था, जिसे वे पूरा नहीं कर सके। प्रतिवादियों के विद्वान अधिवक्ता को अगली दलील थी कि प्रतिवादी संख्या 3 एवं 4 को संविदा दिनांक 6/10/83 की जानकारी नहीं थी। अतः उस संविदा के आधार पर प्रतिवादी संख्या 3 एवं 4 द्वारा गुड फेथ में क्रय की गई विवादास्पद मकान के संबंध में क्षति नहीं होगी। इसके प्रदर्श 4 के अस्तित्व में आने के बावजूद भी प्रदर्श ई के आधार पर विवादास्पद संपत्ति के संबंध में कायम हुए प्रतिवादी संख्या 3 एवं 4 के स्वत अधिकार हित एवं कब्जा को अस्वीकारा नहीं जा सकता। मगर वादी के विद्वान अधिवक्ता की दलील थी कि प्रतिवादियों की दलील में कोई दम नहीं है, क्योंकि प्रतिवादियों का यह पवित्र कर्तव्य था कि वो विवादास्पद संपत्ति के संबंध में पूरी तरह छानबीन कर क्रय विक्रय की बात करते और विक्रय विलेख निष्पादित कराते। मगर जैसा कि अभिलेख पर उक्त वर्णित साक्ष्य आया है, उससे स्पष्ट है कि प्रतिवादी संख्या 3 एवं 4 इस संबंध में कोई छानबीन नहीं की है, जबकि अन्य प्रतिवादियों के साथ साथ वादी से भी उनका पूर्ण परिचय था तथा वादी एवं प्रतिवादी संख्या 3 एवं 4 बहुत कम दूरी पर आसपास निवास करते हैं। उनके संदर्भ में वादी की तरफ से प्रस्तुत की गई उक्त दलील में काफी बल है। प्रतिवादियों के विद्वान अधिवक्ता की अगली दलील थी कि अभिलेख पर ऐसा कोई साक्ष्य नहीं है जिसको मद्देनजर रखते हुए यह कहा जा सके कि इकरारनामा दिनांक 6/10/83 के निष्पादन के बाद से वादी विवादास्पद मकान से संबंधित बकाया विक्रय मूल्य भुगतान करने के लिए तत्पर रहे। अतः इसके अभाव में भी वादी के वर्तमान वाद को असफल घोषित किया जाना चाहिए। मगर वादी के विद्वान अधिवक्ता वादी द्वारा दी गई प्रतिवादी को वकालतन नोटिस तथा उनके द्वारा न्यायालय के आदेश के आलोक में बकाया विक्रय मूल्य 25,000 रुपये जमा करने से स्पष्ट है कि वादी बकाया विक्रय मूल्य भुगतान कर विक्रय विलेख निष्पादित कराने के लिए बराबर तैयार रहे। दिस शोज रेडीनेस एंड विलिंगनेस। वादी के तरफ से प्रस्तुत की गई यह दलील अभिलेख पर आए उक्त वर्णित साक्ष्यों के आलोक में काफी बल रखती है। प्रतिवादियों के विद्वान अधिवक्ता की अगली दलील थी कि वादी द्वारा विवादास्पद संपत्ति क्रय करने के संबंध में एक ही तिथि 6/10/83 को बातचीत अग्रिम की लेन देन एवं इकरारनामा निष्पादित होने की बात अस्वाभाविक है तथा वादी के
इसमें वो फाइंडिंग कहाँ है कि they had whether the purchaser had any notice?
Purchaser.
Defend number 3 and 4.
But how it
Had any notice about previous agreement? Whether they were bona fide purchasers?
even if they are bona fide purchaser,
Like, is there any finding? There is no issue. Is there any finding specific performance of contract को देने के लिए? There are minimum conditions required under law.
जी,
One of the conditions is that he should be a bona fide purchaser for value and without notice of the agreement.
so whether it was upon the purchaser to prospective purchaser to issue notice or it is upon the vendor to intimate them that,
No.
that look here there was
I'm just asking you, there is no such issue frame. Is there any finding recorded?
the
That
witness.
you see, defendant number 3 and 4 simply stated that the agreement was forged and fabricated.
Yes.
Right.
So
Was there alternative case also that they had no knowledge about this agreement?
it has been asserted by the defendant number 3 and 4 that they had no knowledge and
Show
being
me. Show me please. One sentence. दिखाइए जरा. Written statement.
It is pleaded.
Read it. But no issue framed. Issue has not been framed.
It is pleaded that we are bona fide purchasers, 3 and 4, and we are not. It is pleaded like.
But I don't find any issue framed.
There is no issue.
That's
so,
right.
so I am putting a question to myself, Vaji, incumbent upon me, prospective purchaser, to give him notice.
You can put questions, but you see the law.
Yeah.
It is for you to at least state that you had no notice. That was whosoever is the purchaser. You see, the plaintiff is already in possession of the property.
Yes, I am plaintiff. Here
That's right.
Yes.
We are not concerned
Ah.
who is the plaintiff, but
Yeah.
important is plaintiff is in possession of the property. Right? He relies upon an agreement of sale. Correct? And now we have another purchaser when he comes for execution of the specific performance, and prior to that the sale deed is already executed. Prior to filing of the suit, the sale deed is executed in favor of defendant number 3 and 4.
3 by defendant number 1.
By defendant number 1. And therefore, had the defendant number 3 and 4 pleaded or said anything that they had no knowledge about the agreement? This is what I am asking.
Yes.
He says that there was a pleading to that effect, but no issue as such has been framed. There is no such issue. Yes, please continue, read it, complete.
बकाया विक्रय मूल्य 25,000 रुपये जमा करने से स्पष्ट है कि वादी बकाया विक्रय मूल्य भुगतान कर विक्रय विलेख निष्पादित कराने के लिए बराबर तैयार रहे। वादी के तरफ से प्रस्तुत की गई यह दलील अभिलेख पर आए उक्त वर्णित साक्ष्यों के आलोक में काफी बल रखती है। प्रतिवादियों के विद्वान अधिवक्ता की अगली दलील थी कि वादी द्वारा विवादास्पद संपत्ति विक्रय करने के संबंध में एक ही तिथि 6/10/83 को बातचीत अग्रिम की लेन देन एवं इकरारनामा निष्पादित होने की बात अस्वाभाविक है तथा वादी के कथित बकाया विक्रय मूल्य का अभाव था, अतः संबंधित संविदा अपने आप में समाप्त हो जाती है। मगर उक्त वर्णित साक्ष्यों तथा एवं तथ्यों एवं वादी द्वारा दिए गए नोटिस तथा उनके द्वारा जमा की गई विक्रय मूल्य की राशि के आलोक में एक ही तिथि में उक्त कार्रवाई होना अस्वाभाविक नहीं है और न ही बकाया मूल्य का अभाव कहा जाएगा। प्रतिवादियों के तरफ से दलील दी गई कि वादी के तरफ से परीक्षित कोई भी साक्षी अपने कथन में अपने समक्ष प्रतिवादी ईरा मित्रा का हस्ताक्षर इकरारनामा 6/10/83 पर होना नहीं कहते हैं, अतः ईरा मित्रा के हस्ताक्षर को साबित नहीं किया जा सका। यह सत्य है कि इस तरह का कथन कोई भी साक्षी नहीं किए हैं, मगर इस आधार पर विधिवत संपादित संविदा दिनांक 6/10/83 को इनकार करना विधि सम्मत नहीं होगा। प्रतिवादियों की तरफ से भी कहा गया कि यदि संविदा दिनांक 6/10/83 सही में निष्पादित रहती तो वादी विवादास्पद मकान के किराए की राशि मार्च 84 तक भुगतान नहीं करते, मगर जैसा कि वादी के कहा गया और अभिलेख पर जो भी साक्ष्य आया है उसके अनुसार इसी दलील में कोई बल नहीं है, क्योंकि इस आधार पर प्रतिवादी संख्या 1 एवं 2 के द्वारा निष्पादित संविदा को अस्वीकार नहीं किया जा सकता है और न वादी संविदा दिनांक 6/10/83 को निष्पादन से विवादास्पद मकान के स्वामी हुए थे। इस संबंध में किसी भी पक्षकार द्वारा अन्य कोई दलील नहीं दी गई। जहां तक प्रतिवादी संख्या 5 एवं 6 के हिस्से के संबंध में उक्त संविदा का प्रश्न है, प्रदर्श 4 एवं प्रदर्श ई के अवलोकन के साथ साथ स्वयं दीपक मित्रा एवं ईरा मित्रा के कथनों से स्पष्ट है कि दोनों प्रतिवादियों उक्त प्रतिवादियों के संबंध में पावर ऑफ अटॉर्नी ले लिए थे। इस प्रकार उक्त वर्णित साक्ष्यों, तथ्यों एवं वर्तमानवाद की संपूर्ण परिस्थितियों के आलोक में स्पष्ट है कि संविदा दिनांक 6/10/83 का निष्पादन प्रतिवादी संख्या 1 एवं 2 द्वारा वादी के पक्ष में किया गया था तथा उसमें लिखित तथ्य अभी भी जायज हैं एवं प्रतिवादियों पर बाध्यकारी है। स्पष्ट है कि वादी इस संविदा के आधार पर प्रार्थित डिग्री पाने के हकदार हैं, मगर
Power of attorney has been exhibited. Power of attorney has been exhibited.
It was power of attorney in favor of defendant number 1 and 2 by other.
Anyways, we'll continue tomorrow. The hearing of these cases have commenced. Close this case for further hearing tonight at 10:30. और कोई रखें कल? एक केस किसका? एक केस ऑलरेडी है, उसके बाद इसमें एक कोई मैटर है ऑर्डर्स में लगा हुआ बहुत पुराना मनी सूट जिसमें रिक्विजिट्स नहीं पाई हुआ है, वो कौन सा मैटर है? अच्छा, कल से आ रहा है
ये कल यस्टरडे का लिस्ट आज का लिस्ट ये
इसको 10:30 पहले इसी को सुन लेंगे कंटिन्यूटी में, ठीक है? दैट वुड बी बेटर। कंटिन्यूटी में सुनना ठीक है। और एक चीज और सकता है, वो आज के लिस्ट में एक मैटर है मनी सूट जिसमें डिपॉजिट्स नहीं पाए, नोटिस हुआ था सब्सटैंशियल क्वेश्चन ऑफ लॉ बनने के बाद। ऑर्डर्स में होना चाहिए, आप भेजे दिखाइए
उसमें होगा पुटिंग
नहीं, उसको तो ऑलरेडी सब्सटैंशियल क्वेश्चन ऑफ लॉ फ्रेम्ड है।
तो मनी रिसीव टाइम रिपोर्ट करते ऐसे मनी रिसीव टाइम
मनी रिसीट नहीं, रिक्विजिट्स नहीं पाए, आप फाइल भेजे थे बस देख लीजिए।
एक प्रेयर था, एक हमारा ऑर्डर 41 में है। कल से मेरी तबीयत ठीक नहीं है, हाई फीवर था, लेकिन ये केस पुराना था इसमें, इसलिए हमको आना हुआ था। तो अगर उसमें कोई एडजॉर्नमेंट मिल जाता तो।
कौन सा आइटम नंबर?
अंडर ऑर्डर 41 रूल 11 का सर पहला केस।
पहला केस
आइटम 33
सेकंड जुलेखा खातून
33
इसमें पिछले बार जब टाइम हम लिया था तो उसमें 10,000 रुपये लॉस हुआ था, उसको भी भर दिया। लेकिन इतना है ना, इतना स्वेटिंग भी हो रहा है दवाई खाने।
ठीक है, इसको रिटर्न कब कर देंगे? नेक्स्ट वीक कर देंगे।
थोड़ा सा लंबा ही देते, फिर हमको इसके लिए भी गया जाना होगा, पिताजी श्राद्ध हुआ।
किसका श्राद्ध?
और जब वो पितरपक्ष वाला चल रहा है,
पितरपक्ष का श्राद्ध।
that is
पितरपक्ष में हम लोग के यहाँ छुट्टी नहीं होती,
नहीं,
इस तरह का सबमिशन मत किया।
नहीं, हम 1-2 दिन के लिए हम जाएंगे।
ये सब जो है ना, दिस इज